chickadees. Happy Monday to you. So happy to have you all back here. It feels a little bit like I haven't been here in a really long time, but I know it was just Wednesday that we were all together. It just seems like a long time. Hello, Kelly. So happy to have you back with us today. And Ava, good evening to you. And someone new, 1126 CDCK. I think that's how I say that. Good evening. Thank you so much for joining us. And no, it doesn't feel like a Monday at all. Short week this week. So we do have that to look forward to. Listen, I hope everybody got my notification in which I said to make sure that you have hydration, some sort of emotional support animal or pillow or friend. You're going to need it for this one. And that you also need to have some antacids because this one's a spicy one. So, 1126. Gotcha. You are free, Kelsey. Gotcha. So, before we get into everything, let me just remind everyone, if you're watching on replay, please make sure that you remember to hit the like button. And you might want to comment to me. I'd love that. I always respond to comments. And I'd like to thank everybody that has joined tonight. And if you could hit the like button, tell all your friends, even replay crew, tell all your friends what a great time you had here this evening at Ms. Demeanor's house. I have a full belly. I am ready to go. Mr. Demeanor made a fantastic meatloaf this evening, which is one of my favorites. And so I made sure no hangry was going to happen for me tonight. I've got my big drink. I mean, she's a big one. And we're going to get into all of this about Zachary Adams. So let me give you a little background, a little breakdown on the case. Holly Bobo was abducted in April of 2011 in Tennessee. It was kind of in the western part of the state. Think Memphis-ish area. She, her body was not found until 2014. They did not, if memory serves me, they did not find all of her body. They found her skull and some personal effects of hers. There were several different suspects at the time, and you all know we're going to get the full trial because we're going to start that on December 5th, the evening. It's a Friday evening, and we're going to do it that night. We'll start it that night. I only watched the first 2 days of testimony, and my jaw was on the floor. So we're going to do that. And y'all are going to see exactly what was going on. I think it's going to be good this way that we're seeing all of this post-conviction relief hearing, and then we'll watch the trial because things are going to make a lot more sense as to how it was handled. So there were several suspects. Unfortunately, they narrowed it down to 3 individuals. Those 3 individuals, well, technically 4. It was Zachary Adams, that's who this hearing is about, Shane Austin, Dylan Adams, which is Zachary Adams' younger brother, and Shane Autry. Shane Austin, unfortunately, took his own life, and so he's no longer with us. Dylan and Jason both, the 2 of them, ended up making a deal with the state in exchange for their testimony in which they pointed the finger at Zachary Adams. They have both since then recanted that testimony, and I can tell you, based on what some of the things we're going to see in these highlights from the hearings, there are problems with the evidence. It doesn't look to me like it supports a conviction for Zachary Adams, and it definitely looks like he was not given a fair trial. We're going to see exactly what goes down here. We're going to start with the hearing that took place 3 months ago in August, and I followed it very closely then. If you followed me on TikTok at that time, I had some TikTok videos about it. I've been keeping my eye on this one for a long time. So we're going to start there. By the way, little tidbit, I might have had someone very, very close to the defense team reach out to me over the weekend. So can't tell you who it is, and I can't tell you what we discussed at this time, but I can tell you that there was communication with someone very, very close, and they let me know how appreciative they are that I'm sharing this and also trying to get the word out, and that I can see kind of what the issues were in this case. So, shh, don't tell anyone. I'm hoping in the future, maybe we could pick the brain of Mr. Bates. He is the defense attorney that's handling Zachary Adams' post-conviction relief hearings and case. So now that I've told you all of that information, let's get into it. So because I had to scribble things down, normally I have it electronically, but I'm old school tonight with my notebook. So this first person that we're going to watch, her name is Beth Boswell. She is an assistant district attorney for that also worked on this particular case. So let me get us all set up here. And if y'all can't hear something like that, you need to let me know. I'm going to try to boost her up a little bit here. And all righty, here we go. Here's the first little clip I wanted to highlight. Oh, before I forget too, it's going to be a long one tonight. There's a lot to cover. So, I mean, if we go until 9:00 Central Time, it won't surprise me. So prepare yourself. And if you need to bounce out and watch it on replay, I totally understand. But I'm going to plug through on this. There's a lot to cover.
Were you present after coming to Decatur County for the attempt to recreate the cell phone journey of Holly Bobo on April 13th, 2011?
Can you ask that again?
Sure. Did you work with law enforcement and other people to recreate where Holly Bobo's cell phone was on April 13th, 2011?
No.
Did you ever work with anyone regarding trying to recreate her route that day?
No. Other than them advising me of certain things about the phone evidence, but no recreations.
And when you say them, who was them?
Law enforcement, TBI and/or TBI for sure.
Anybody else?
I mean, a lot of people were working on the case, so I don't know for sure.
Marshal John Walker?
No, I had very little involvement with Marshal Walker.
At some point, were you part of a discussion regarding installing a wiretap in the home and on the phone of Terry Britt?
Yes.
And when did that start?
I think the first mention of Terry Britt in the case was somewhere in the middle of 2011, maybe July or August, somewhere in there. So there were a lot of things going on. There were numerous suspects. So as to Britt, we did begin working on him. And January of 2012 was when we were doing the wires and search warrants and things like that.
Why did it take so long to begin the wiretap?
It's hard to get wiretaps. I mean, that's the whole point. There are certain levels of authorization. You can't just swear to something with nothing there.
Did you review the application for the wiretap?
I did.
And the witness can be handed Exhibit 56.
Oh, I'm scooting us.
Let's go. I'll go through trying to find. Let's go through it. Exhibit on page 9. Identification of Terry Lee Britt as a suspect. You know when it was determined that he was a registered violent sex offender?
I'm sure we knew that early on. I believe we had a list of all the sex offenders within so many miles of the crime scene.
And his past predatory behavior, how long did it take you to get that?
Some of that would have been a little longer because we were getting, I think, offense reports and judgments and just accumulating knowledge as to what the past was.
Terry Britt's alibi proven false. How long did that take to develop? Page 10.
I think there's some discrepancy as to that, but I do believe that there's a time period during April 13th of 2011 where there were some phone calls between he and his wife, as I remember, and he had indicated he had been with her the whole day. It was a very short time period where there were phone calls. I went, without even looking at this, going off my memory, it was in the middle of the day, like 12 to 1 or 2, something like that. There were some phone calls back and forth between them, which did indicate that he lied, at least as to that time period.
Terry Britt lived
Well,
very
you-
close to the
You
Bobos.
reviewed this prior to it going to Judge McGinley.
That's correct.
And in bold, on essentially almost page and a half, page 10 to 11, is Terry Britt's alibi is proven false.
Correct.
Then
I would like to say, though, these are very fluid. So the probable cause that's listed in here, of course, is as we know it at the time. So I'm noting on page 10 where you asked me to look that it says they did not purchase a bathtub on the day of April 13th of 2011. That was because Terry Dykes went to All Good Salvage to ask if a bathtub had been purchased, and they did not have a record of it. I let Terry Dykes know that as a state ADA in the 24th, I was very familiar with Slim All Good and All Good Salvage, and that they did not keep good records by anybody's standards. I know at a later time we did find a receipt at the search warrant in January of 2012, and Dykes took that back to All Good Salvage, and though they didn't have a receipt, they did verify that was Slim All Good's writing on the receipt. So it is fluid. But yes, at the time that we did this, All Good had said that they did not buy a tub.
were you aware that this bath receipt was put in the safe at Terry Britt's house?
Yes.
That struck you as unusual?
No, not at all. I think he also had a receipt for purchasing a Coke at a gas station. For a sex offender, especially as organized as he is, and any others, they heard of a crime like this. I'm sure they kept anything they could to show where they were that day.
Okay.
I think that's weird.
Or where they chose to go.
I can't speak to what they choose.
Changes in physical appearance, page 11 and 12. And if you look on page 12, middle of the second paragraph, it states September 1st, 2011 was when Mr. Britt was observed.
Okay.
Is that,
I don't know what you're asking.
well, I'm trying to figure out why did it take so long from, if the change of appearance was in September, why wait until January?
If I can explain this to you pretty easily. When this crime happened, there were hundreds of potential suspects, and this carried on throughout. It was piece by piece evidence, day by day, hour by hour, and year by year. So we were looking at people that went to nursing school with Holly, her friends, the family friends, anybody that had done work at the Bobo's house, sex offenders. The list goes on and on and on. And nothing was digital at this point. So going back to when we were actually at the command center, the way that was working, everybody showed up. It was social media. We had four-wheelers. We had people with horses, people with dogs, metal detectors, and all we could do was try to organize this. So people were calling in and they were getting a handwritten piece of paper that had somebody called in. They handed it to a team of law enforcement that could be made up of people from multiple different agencies. They would take that piece of paper and then they would go and interview that person, and they should interview wherever that leads them until they clear that. Then they would bring it back and they'd put a check mark on that piece of paper, and then that piece of paper would get filed somewhere, and it didn't get entered until a lot later. So we weren't only working Terry Britt. We were getting focused, towards the end of 2011 and then into 2012. We put a lot of emphasis on him at that point, pretty much throughout that year, but there were other things still going on constantly.
Is that the
Lovely Flight. You're going to see that most of them have this demeanor. And no, in 2011, it would not have been digital. We need to kind of go back in time as to what things were. This one is not the worst of it. She gets a little dicey, and hello, Jen. Thank you so much. We're going to keep going here.
Reason for the delay, or was it your prior statement that it takes a lot to get the search warrant?
No, I think it was all of that. I'm just saying you can't just go get a wire overnight. So, but as far as any delay, we were working everything as we could work it, but he was still not the only person. Leads were still coming in and we were still going through old things. And we were all working 15, 16-hour days, sometimes more.
Understand. And y'all use the analysis of Holly Bobo's cell records.
Correct.
Mr. Britt's proximity to the physical evidence recovered.
Correct.
Mr. Britt's pre-abduction knowledge of Holly Bobo.
Correct.
Additional predatory behavior of Mr. Britt.
Correct.
Enabling and suspicious behavior of Janet Britt.
Correct.
And your office, in conjunction with TBI, submitted there was probable cause that Mr. Britt had committed these crimes.
Correct.
And I'm going to ask you, when did you know that Mr. Britt should have been prosecuted successfully in Madison County for the attempted rape of Tequila Jones?
I'm not ignoring. I'm not.
I don't understand the question. Prosecuted successfully. I don't know what.
All right, I'll rephrase.
All right, objection sustained. Rephrase question.
What's your knowledge of Mr. Britt and Tequila Jones?
I knew that there was a case. I believe she was a prostitute. It occurred in a moving vehicle. I think she had about the same baggage you expect a prostitute to have. And I know that Madison County did come back later and charge that case. They did think it was going to be very hard to win, but they didn't have to get there because he wound up pleading guilty to it.
Okay. So when did the crime take place?
It's probably in here, but I would guess say 08, 09, something like that.
Okay. And were you aware of Mr. Britt's preliminary hearing in general sessions not going forward?
I don't remember that.
Do you know when the indictment was in Circuit Court of Madison County?
I'm guessing, but I think it was 2012 sometime.
Okay. And how soon after that did Mr. Britt plead, to your knowledge?
I don't remember that. It would be on the judgment sheet.
Okay. So you might have figured out by now that there seems to be a pretty good suspect, Terry Britt. He has been involved in some other multiple issues with young women and an attempted grape. And also, yes, she is nervous and she does come across a little abrupt, but please understand, this is Tennessee. I have them at 1.5 speed because if I don't, we will be here until midnight because they talk really slow in the South. So we're going to move on to the next section here.
I really don't know that I ever reviewed these line sheets.
Well, you know what it is?
I do know what this is, but I don't know that I reviewed this.
Okay. And then can you look at
I would have been party to anything that anybody thought was relevant would have been told to me by TBI.
All right. And then look at line 45. And can you read the synopsis?
Call from SM to TB talked about damage to house and trailer. SM asked if TB had a black light, said the black light would show blood and show where the law may have sprayed luminol. SM told TB to be careful what he said because they might have phones bugged and they might have the house bugged too.
And what date was that?
January 18th.
All right. You would agree with me that's significant.
It's a call that he had where somebody's telling him that he needed to be careful about things.
You agree it's significant?
I mean, it wasn't anything he said. It was something she said. So
If you say it's not significant, just say it's not significant that the target of the wiretap was told he might be being wiretapped.
I mean, I'm not saying it had no relevance to this, but I don't know that I would find this that significant because he didn't say it. I mean, I think most criminals know that there's a chance that they could be wiretapped. So if the point is, do I think he could have had knowledge? Possibly he could have had that or even thought it on his own. And this person told him that.
All right.
Oh, really? Oh, really? That is what we're going to go with? We're going to roll with that. Oh, okay. Okie dokie. I'm not buying this. And why so evasive? Just answer the questions. All right, next section here. Y'all getting the flavor? This is why I said it was going to be spicy. And this is nothing compared to, this is going to continue to build. You'll see.
Because they were, we searched all the vehicles.
In 2012, after the search warrant to Miss Janet Brett, do you remember a meeting with Terry Dykes where he presented a PowerPoint?
I do.
All right. Do you remember when that was?
I do.
When was it?
February of 2013.
Okay. So now let's talk this 12-month period from February 2012 to February 2013. Who was the lead case agent on this case?
Terry Dykes.
How long had you worked with Terry Dykes?
I really don't know the answer to that, but I did work cases with him. I don't know when he came on at TBI or.
Okay. Who called for the TBI PowerPoint meeting?
The way the PowerPoint came about was Terry Dykes took a copy of his PowerPoint to Hansel McAdams and handed it to him, saying he wanted Hansel to review it and he wanted to come to present charges as to Terry Britt to Hansel, which he had no authority to do. Nobody from TBI authorized it. At the time that he did that, all of the TBI agents were no longer, everyone believed that Terry Britt had been excluded as a suspect. Without the knowledge of anybody with TBI or his superiors, which he should have had to try to present an actual case for charges, he gave it to Hansel McAdams, asking for a meeting between just he and Hansel and nobody else. Hansel McAdams said he was not going to do that, that it was his understanding that he had been excluded, that we would have the meeting, but he wanted me there and all of the agents and supervisors from TBI, Western District of Tennessee. Then I called everybody to set the meeting up.
All right. Was Marshal John Walker there?
I don't remember that.
FBI agent Art Vivros.
Art retired in December of 2012. I don't recall him being present.
Could he have been there?
He could have been.
Anybody invite him, to your knowledge?
I wouldn't have, because he was retired. I would not have invited him.
At this meeting, was it discussed? You know, on January 17th, Terry Britt said he might be being bugged.
I don't remember that.
Did anybody say, you know, the audio failed? And that's the big reason it didn't get evidence. The audio equipment failed.
It just wasn't clear hearing, sir. Like, you couldn't hear it clear. Understand what's in the document. The document says that it did. But again, we were trying to capture that very first conversation, which we were able to hear.
Well, it's important when TBI reports to a judge to be honest.
That's right.
So is there any reason to believe in February of 2012, Agent Booth was being dishonest to Judge McGinley when he said the main reason we didn't obtain evidence is equipment failure?
No, and he also said that the stimulation, he referenced as to the stimulation. It didn't work great. It did not work great. You could hear things, but you couldn't hear clear conversations. You had to really listen hard. I mean, it wasn't what we expected to have after getting it in there, for sure.
Now, the PowerPoint presentation, do you remember, what do you remember from the meeting?
I remember that everybody in the room, I do believe Ricky Inman may have been there, who also still believed that Terry Britt had done the crime. He was with the Decatur County Sheriff's Office maybe at the time. But as far as the TBI investigators, the supervisors, and myself, we had excluded Terry Britt. I remember specific things, and it was a very long PowerPoint. We all listened. We made remarks. We asked him questions. The majority of the PowerPoint were other people that Terry Britt had stalked, which, since we had cleared him, this was not going to be there anyway. But had you gone to trial on Terry Britt, he had committed this crime and went to trial, all of those other stalkings would have been 404B. If anything, those would have never come in. And
But he was stalking other people.
I don't know that you could have used them for impeachment as well. But as I said earlier, Terry Britt, could have been good for this crime based off that history alone and based off his stalking and the prior rapes. I remember a few specific things that still stick out to me now. One was based off phone evidence. There was a period of time where there was a gap or there was nothing. I don't know how to explain it, but I remember that Terry Dykes said, here's where the rape occurred. The rape occurred right now. And we said, what rape? Do you have a rape kit? It has Terry admitted to rape. Do you have a witness to rape? Like, at the time that we did that, you would assume that a predator, whoever that person is, that might be the motivation for the crime. But he specifically had in there that this is where the rape happened.
And you use some words. You got rape kit, and that's a kit you use on a victim if they've been raped.
Right.
Witnesses to a crime.
Right.
Now, at the time, what was your understanding of where Miss Bobo traveled on April 13th, 2011?
Before we come back to that, can I finish the other points of the PowerPoint? Or do
Yes,
you-
ma'am.
Okay. The one thing I remember was on the day of April 13th of 2011, Terry Dykes said that a truck or vehicle that looked like Terry Britt's went past Am Farm on 641 or 69. We didn't know if it was his. You couldn't see who it was. It didn't stop. It didn't do anything except go down 641, which everybody does all day long in that area.
Let me ask
The
you, like, do you remember Mr. Britt's cell phone records showed he was actually in the same area where the Am Farm vehicle was?
I don't, and I'll answer what you have to on the cell phone stuff and my knowledge of that. But the purpose of the PowerPoint was that he drove by where her phone was found. Is the way he presented this. And as I said, he didn't stop. He didn't throw anything out. And
How does she know that?
obviously later we got other information about the phone and the location of where it was.
All right.
How do you know he didn't throw
I have my
anything out?
Diagram. Are you
Just making
discussing
stuff
this,
up.
I think we marked that as an exhibit, so let's call it out.
Exhibit 15.
We're looking at exhibit 15. Go ahead.
Are you aware, or were you referring to the travel of the victim's cell phone that I have in these purple cards, where there was no activity between 8:26 a.m. and 8:56 a.m.?
I think that's correct.
And did anybody say at the time her remains might be found in this area as well?
I don't recall that.
Have you learned after you left the case that her remains were found in the same area? There was no activity for 30 minutes.
I don't know that.
Were you aware there was a .380 spent round found next to her remains?
I do not know anything that happened with the investigation once I came off the case.
Okay. Did you have a theory at the PowerPoint meeting as to where Ms. Bobo traveled that day?
No, and what I can tell you is I'm not very mathematical at all. Phone evidence in that area, if I recall right, was 2G at the time. On any of my cases that I had worked in the 24th, particularly in the more wooded or rural areas, mostly what we were looking for was who talked to who to be able to corroborate if people were together or not. And it got very dicey with the cell towers and the sectors and what you could actually prove about any kind of location to a certainty. And I recall that there were pings or things with his phone as well as with Zach's and Autry's. So, I mean, there were things going on with the phone evidence, but what was most important to most of our cases was more who was talking to who and when were they talking, because I think it was mile radiuses at that time. And it was a very wide radius. You could not say somebody was right here at this spot.
And I'm sorry, you just said Zach and Autry.
Okay. Tell me how you feel about Miss Beth Boswell. Interesting information we're getting. There was a lot more to it. I'm going to get us to the next section. Good grief, I've got my drink in the way. I can't see what the heck I'm doing over here. Terry Britt's name came up a lot at the beginning of this particular case. And I don't understand why they got away from him so quickly. We're gonna bear with me just a minute. I'm trying to get my life in order here. I don't know why they moved off of Terry Britt so quickly. It's to me, and I haven't watched the trial yet. As you all know, I started to. I think there's a lot more meat on the bone with Terry Britt. So let's go ahead, and this next individual is Art Viveros. This is who she was just being asked about, and she said that he had retired. And the person that is questioning Art is the prosecution. So you have to kind of think of it backwards here, because the defense is the one that presents the case first, because this is post-conviction relief. This is not a trial. So the proof part of it is the burden falls on the defense. And so he is actually being cross-examined by the prosecution.
Good afternoon, Mr. Harris. I want to start off by discussing your retirement.
Mhm.
That who was in charge? Who was your direct supervisor when you were still on this case?
Eric McCraw.
And is it true that you were removed from this case?
That's not true.
Okay, so let's talk about that.
Yeah, let's talk about that. Sure.
So you, two other agents didn't take over for you, having with Mr. McGraw pulling you off the case and putting two new agents on?
Okay, that didn't happen.
Okay, well, please tell me what happened.
Well, I was not taking off the case. Eric and I locked horns a couple times, mainly about the timeline of Clint and what happened that morning. And I'm thinking, Eric, you just got here. We're arguing about the timeline. Myself and Brett Booth came up with the timeline working with Clint and using his phone by seeing the phone calls.
Okay, so I really want to focus on,
And-
like, so you, when you were removed from the case, who made
I
that
was not
decision?
removed from the case.
Okay.
You say that I am. This is news to me.
How did you depart this case?
I retired.
You didn't retire in the face of being taken off the case?
No.
Ultimately, you left the case and two other FBI agents took your place.
Well, I don't know what other two. I know Steve Champagne. I remember Eric McCraw saying, "Hey, Art, I'm going to ask Eric McCraw to help you out with this case, and he can handle some of the electronic stuff."
You've already testified this on direct, that you appeared during the trial of this case and testified for the defense.
Yes.
Did you catch that? Yeah, he appeared for this case and testified for the defense. So in the original trial, this particular retired FBI, but in Tennessee, they're called TBI, Tennessee Bureau of Investigation agent, ended up testifying for the defense because he was not in agreement with the narrative that was wanting to be pushed. And he was vocal about it, and it was not welcome by any means. So the next individual we're going to watch, I wanted you to see the dynamic that was going on. So you're getting a little bit, there were big rifts in the Tennessee Bureau of Investigations on this particular investigation. And yes, we'll eventually, I think, get to that at some point, but Robin Scott 1951 is correct. Terry Dykes, who was the lead agent, was removed from the case because he kept saying he believed Britt did it, just like Art did. And yes, trust is love. Timelines didn't line up and he didn't agree with Eric. I'm telling you, the time when we get to watching the actual trial, that's going to be one of the glaring things you're going to see about this. That things, you'll probably see it in just these hearings. Okay, let me get us to the next one. The next individual is one of the attorneys that represented Zach Adams in the original case. I did not catch his first name. I can't find it anywhere. His last name, I believe, is Gonzalez. So Zach had 3 attorneys in the first trial. He had Jennifer Thompson, this Mr. Gonzalez, and at one moment in time, he also had a Jim Simmons, I believe, was the name. The state had a lot of different people, but the main prosecuting attorney there were 2 main ones, Paul Hagerman, which we'll hear from in just a little bit, and Jennifer Nichols. So this trial was the war of the Jennifers because they were lead counsel on prosecution and on the defense side. They were both Jennifers. So we're going to go ahead and get to Mr. Gonzalez. I think this is going to give you a little bit of a flavor of what some of the issues and the dynamics were like on the defense team. And you're very welcome, Jen. You're only going to have little bits and pieces tonight, but you'll get an idea of kind of the overarching theme with all of it.
In Jennifer Nichols' closing, her saying in her closing argument, and Your Honor, I'd like to refer to Exhibit 40.
This is the defense questioning him.
Page 2734 of the trial transcript.
We need to hand him Exhibit 40.
I can read it. I just, for Your Honor's attention, that it is in evidence, and so that everybody can reference it. Mr. Gonzalez, do you recall Jennifer Nichols saying in her closing argument that the 380 had been excluded?
I don't directly recall that, but keep in mind, one of the problems was I was seated way over there, and Jennifer Nichols was allowed to approach the bar of the jury seating area and lean forward and practically whispered her closing to the jury, where I couldn't hear a lot of what she was saying.
He's not
At one
lying.
point, Jennifer Thompson told me I can't hear what she's saying, and I said, "Well, then go ahead. You need to object." And as I recall, Jennifer Thompson objected. "Judge, I can't hear what she's saying." And the judge said something to the effect of, "Well, the jury can hear her." So I didn't hear a lot of what Jennifer Nichols was saying. I heard some, but I don't remember her saying the 380 was excluded. In fact, in my recollection, the theory of the state from the very beginning was that it was a 380 until they found a gun that was a 32. Then their theory changed that it was a 32.
Oh, it gets better, Kelly.
This exhibit is evidence of the trial transcript of Jennifer Nichols' clothing on page 2734. And she says, I have no doubt that the way he measures them, talking about the bullets, is the way he reported it, but he didn't know how to measure them. Didn't know that remove the projectile from the casing and then measure it. So the expert who testified about the gunshot wound to Holly's head said it matched my words perfectly. Basically, a 32. And if you look at those measurements and you remember his testimony, it excluded a 38. Excluded it.
Is she referring to the medical examiner as the expert? I don't remember that part of her closing at all.
But if you had heard that, objection, Your Honor,
Call for speculation.
Your Honor, he's an attorney, an experienced trial litigator, and if he knows the facts of this case, and had he heard that, I think it's fair game for him to speculate as to what action he would take.
I would have objected. We really frown on objecting during closing arguments because closing arguments is not evidence. But when one side or the other argues evidence that was not admitted, that is a proper grounds for objection during a closing argument on either side.
Is it safe to say that this trial in and of itself was unique, a unique experience for you?
Yes.
Were there any other unique observations that you made during this trial about behavior or conduct of any of the court officers that were involved?
There were some things that I thought were strange. The judge required me to escort Zach in from the hallway over there every morning. I never understood why. And we would stand on the other side of the door there, and the judge would be standing there with a gun on his belt, standing right next to Zach. And at one point, I warned the judge, because as a former Secret Service agent, I'm always thinking about this sort of stuff. I warned the judge that it's probably not safe to stand in such close proximity with a defendant while wearing a firearm.
You think?
And he said something to the effect of, well, if he does anything, it'll be the last thing he ever does. And I found that to be kind of a strange response.
Yes, indeed.
And so then I would escort Zach in to the table. And like I said, I never understood why he wanted me to do that when there were plenty of courtroom officers and deputies everywhere, all of whom were very nice and respectful to all of us. Another event that stands out in my mind is at one point during a break, the judge approached me. And again, I don't know why me, but he approached me and he said, "You need to tell your client to take a plea to save his life." And I found that to be really not only strange, but very out of line. I've never had a judge
Inappropriate.
tell that to me. And I told the judge, I said, well, that's really my client's decision to make. I'm not going to try and convince him to do one or the other. And then we left it at that. The other thing that really stood out to me was one time, I can't remember who was on the witness stand. The state was examining the witness, and we suddenly started hearing football announcers coming from the bench. And the judge sort of started scrambling and messing with what I thought was an iPad or something on his in front of him. And he said something like, "Oh, I don't know how that happened."
Oh, do tell.
That tells me that he was watching football during the trial. I mean, my jaw dropped. I've never, ever experienced, as a Secret Service agent testifying in federal court, as a lawyer, knowing that a judge was watching football during a trial, much less a trial where a man was being considered to be put to death. My impression was that he either had already made up his mind on the guilt and the sentence, or he just didn't care.
Can you imagine?
I'm just speechless thinking about that.
The last thing I'd like to ask you about, after the guilty or the verdict was rendered and you guys moved into litigation, did you have any occasion to interact with Jim Simmons at that point?
Yes, that's where he sort of came alive. I think I had approached, I think it was Mr. Hagerman after that, and I kind of mentioned to him, this should not be a death penalty case. And at that point, we started the idea of, well, if he agreed to a settlement for the sentence, then we can resolve the penalty phase. And we finally reached an agreement on the life plus 50, I think it was. And so it was me, Mr. Hagerman, and Jim Simmons in the judge's chambers working on the judgment forms, filling them out. And I made it very clear that the settlement, to Mr. Hagerman, I made it very clear that the settlement did not include any waiver of appellate rights. And he agreed. So we were in the hallway here, and we had said, okay, let's let the judge know what the agreement is. And so we're in the hallway here with the judge. That's me, Jim Simmons, Jennifer Nichols, and I think Jennifer Thompson was there, although I can't remember for sure. And I told the judge, I said, "Judge, as we're announcing the agreed to sentence, I just want to make sure you understand this does not waive any appellate rights whatsoever. He can appeal the verdict, he can appeal the sentence, anything." And Jennifer Nichols, who was standing right next to me, balled up her fist, looks at me and says, "I'm going to punch you." I have never had an attorney, opposing counsel or co-counsel, ever threaten to assault me over something I said that was clearly part of the understanding of the agreement. And I turned to her and I kind of surprisingly said, "Why? What did I say wrong?" And she didn't respond. And I was also amazed that the judge said and did nothing at witnessing another attorney threatening to assault a fellow attorney in the case.
Did anyone respond, or was it a consensus in your opinion, your understanding that this shouldn't have been a death penalty case? Objection, Your Honor, the relevance.
Objection to relevance, Mr. Chief.
Well, I think it goes to the fact of that the state sought the death penalty in this case, and if there are statements that are made that this shouldn't be a death penalty case, then they entered that pursuit in bad faith.
I think the question was it his opinion of whether or not it should have been death penalty case?
No, I said, was there a consensus when, because he had already testified that he didn't think that it should be a death penalty case, and he made that statement. And so my question was there any response or consensus to that by other members of the prosecution team or the defense team?
Okay, response and consensus are two different things. Objection sustained. You can rephrase the
I'll
question.
rephrase the question. In your discussions, you testified earlier that you were meeting with Paul Hagerman, Jim Simmons, and Jennifer Nichols, and you stated that you didn't really think that this rose to the level of a death penalty case. I know Jennifer Nichols did Paul Hagerman or any of the other members of the state agree with you on that? Objection, Your Honor.
I'm allowed a question. Overruled.
When I mentioned that to Paul Hagerman, I don't think Jennifer Nichols was there. At this point, when we were negotiating the settlement, Jennifer Nichols didn't, to me, seem to be involved in that. It was basically me, Jim Simmons, and Paul Hagerman. And when I mentioned that to Paul Hagerman, as I recall, he said he agreed.
One second, Your Honor. My last question is just this: in your professional opinion, having experienced what you experienced in the trial of this case, do you believe that Zach Adams received a fair trial?
No.
I reject it.
Uh-oh. No, did not receive a fair trial. Yikes. Can you imagine a judge who's probably watching the Vols? Y'all know that's probably who he was watching. He was absolutely all tuned in to see the freaking Tennessee Vols play. They were probably playing Alabama. I'm going to give you just a little flavor of who Terry Dykes is. I'm not going to go over all of his testimony. There's not a lot there other than kind of what everybody else has been saying, which is that there was a rift in the TBI, and he was absolutely wanting to follow the evidence to see where it took them. So let me get him pulled up here. And I'm sorry, I keep forgetting to click my closed captions back on. So I'll try to be better about that. And I do still have us at 1.5. So this, I'm going to take us way back here, just so that you get an idea of who he is in that. He seemed very respectful. I had no issues with his testimony. I know that he resigned about his testimony. He says he resigned about 3 months after the PowerPoint meeting.
Did they communicate to you what they were doing?
No, they communicated to me who they had developed as suspects and information they thought needed further detail.
Approximately when was that?
It may have been around this time. It may have been around September of 2012.
At this point, well, Your Honor, if I can make this the next convert into evidence.
Is it an IR?
Yes, sir.
She asked more questions.
Created as part of this investigation.
Yes, sir.
An IR is an
You had any
investigative
reason
report.
To know why it was not converted to an IR.
No, sir. It has all the markings of what would be an IR.
Are you catching that?
Agent John R. Mayer.
Mayor? Yes, sir. Yes, sir.
How long was he involved in the Bobo case?
From the beginning, probably 1.5 years, and then he retired.
Do you remember discussing this document with other law enforcement or prosecutors?
I do not.
Was it your understanding this was going to be converted to an IR?
Yes, sir. It should have been. It should have been an IR. Not sure why it wasn't.
Yeah,
It was
should have
submitted as
been.
an IR.
Should have been an
Well, I move to
IR.
mark this into evidence.
going to let you do a little more about authentication. I didn't hear anything about who created it. So
Okay.
I'll let you ask some questions.
Okay, let's,
I'm going to
Unleashed at the
flip
bottom
through
of
this.
who wrote it. and
Like
put it
I
in the
say,
system.
there's
okay.
I don't
You know
want to
who
spend a
wrote this.
ton of
I wrote
time
this, yes.
on Terry Dykes and his testimony. It is available if you do want to hear all the ins and outs of it. He does explain how there was like a split with the TBI, and this group of people thought that the three of them did it, and this group of people thought that Terry Britt was the best suspect. And so that's what this testimony is about. Like I say, there's way more that's more important here. So I'm going to go ahead and get us going on some of the other testimony. The next person that I have is Kathy Ferguson. She is a law enforcement officer. And oh boy, guys, wait until you see some of this. So what the story was, that the claim is that the three of, well, I believe it was the three of them. I don't think Shane Austin was with them for this particular part, but the three of them went to this river and they took Holly there and they shot her in the back of the head after, of course, she was SA'd by two people, two of them, Zachary being one and Jason Autry being the other. And then they put a bullet in the back of her head, and someone else heard these shots and they were boom, boom. I mean, well, you'll hear the testimony, but heard these shots. So this particular law enforcement officer is going to testify and show you the evidence of a test that they did that shows the decibels. So, and I want you to pay very, very close attention to what your ears hear for this testimony. Here we go.
Prior to Mr. Autry testifying, did anybody go out into the bridge and shoot a .32 revolver to see what sound it made?
No, sir.
You agree with me, Mr. Autry? His baritone voice said it made a large, loud boom, boom, boom.
Yes, sir.
The Martins flew
Yes, sir.
from hundreds and hundreds of yards away. A bass fisherman approached. That's Autry's story, right?
That he heard a boat crank up and leave. Yes.
And now, after the filing of my petition, you're on notice. I don't think a .32 makes that sound. You all had received where one of my investigators recreated that, correct?
Yes.
You took it on, what's the machine that measures the sound?
The decibel reader.
You took that.
I did. They didn't work very well, but I took them. Yes.
And I received it.
Did they?
Court, May 19th, correct?
Yes, sir. Because we had just, well, I had planned 2 other times to try to do that. One was in January of this year and a snowstorm happened. Couldn't do it. Another was in April and it stormed and flooded. I couldn't get down there. So the date in May when I went was the only opportunity that I had because I had to coordinate with 2 other agencies to help in that. So it took some time to make that happen.
And we're just going to play them. I'm going to label, let's take the
Oh, yeah.
identifying number and we'll play it. First one will be MAH00001.
This is going to be entered as an exhibit.
Yes, I'm going to collect it.
Objections? We'll move them in as exhibit 99.
Here we go.
Test 809 AM May 6th, Tuesday.
Next recording. Yep. This is video test is ready. Next video, first test.
Lots of road
Power
noise,
lamp,
huh?
32.
Today is May 6th, 2025. We're doing an acoustics test at the Tennessee River Bridge. The first weapon we're firing is a .32 Smith & Wesson revolver. Okay, when you're ready.
And what's the apparatus on the left and the apparatus on the right?
Did y'all hear that? Little snap.
Today is May 6th. Today is May 6th, 2025.
Those are,
What's the apparatus on the left and on the right?
the apparatus on the left is a decibel meter, and so is the one on the right. The one on the left is very old, and the one on the right is a newer model.
Okay. Are they both measuring the same sound, or is one closer and one's further away?
They did not operate as I thought they would. The one on the left, I had a tutorial from a forensic scientist, a former forensic scientist that told me how to use it. I could not get it to operate, or maybe it was operating correctly, but the numbers rarely changed when we did these tests. And the one on the right, I don't know if it was picking up on the gun or me talking or the traffic or what. So I just wanted to see what kind of decibel level we could see.
The issue is that even if you have a baseline sound level, decibel level, that sound should spike it, even if it's just for a moment. And it did. And you're right, Kelly. It was light. It was just kind of a crack. But she is standing right next to him when he shoots the gun. And it's still not very loud. We'll keep watching.
And you would agree that by and large, the gun never registered higher than the traffic above on the interstate.
I think part of it is the video camera. It's just a standard video camera that we were issued in the TBI. It picks up whatever is maybe has the highest range. I don't know. I'm not an acoustic expert. So all I hear here is the interstate traffic. But on the videos we'll watch in a minute, when we're further out on the river, you hear the water splashing against the boat. You hear the gunshot, and you hear less of the interstate traffic the further away you are from the river, from the interstate.
And you can also agree with me, there's no boom, boom, boom echo.
I heard it. It's a loud crack. I would not have described it as a boom, but it is a loud sound.
In other words, you're certainly familiar with firearms that make echoing sounds based on powder and the cartridge.
Well, and depending on where you are when you fire it, it would echo. Yes, sir. That would be contributory.
Okay, we're just going to walk through these videos.
Today is May 6, 2025. We're doing an acoustics experiment at the Tennessee River Bridge. The first weapon we're firing is a .32 Smith & Wesson.
That one you could see it spike.
All right, here's the second gun we're firing. It's a .32 long. Do it one more time. Hang on. Sorry. Go ahead.
This is
Off the target.
a mile from the
Are these videos
target.
in the order that we gave them to you?
I'm not sure.
Okay.
I think it said at the bottom.
It does, but I didn't put that on the videos. Someone in your office must have done that. I didn't put that header at the bottom of the video.
Exactly the way that we see
Okay, then this would have been at 1 mile. Yes.
If you just look at the bottom, I think it comes across.
It did, but I didn't put that on
Okay,
there, is
fair
what I'm saying. So I want to make sure that they're not out of order.
Yes. Fire away.
Fire one complete. Stand by, two fire, done two, when you're ready.
All right.
Fire two complete.
Did y'all hear anything? Because I didn't. And I've listened to this multiple times. I didn't hear anything. Now we're 3/4 of a mile away.
That's fire gun one.
You tell me, Kelly. Can you hear it? We're now a half a mile from the target. I'm not hearing anything. Are you still hearing anything? Because I don't hear anything.
You're good.
I might have heard something that last time. You think you're going to hear it with the motor running on that boat? That one I heard, finally. I heard it at 0.10
You agree, no boom,
miles.
boom, boom.
I could hear the gunshots from 3/4 of a mile in. The audio is not clear because it's picking up all the other things that are closer to my camera.
Sure.
I would characterize it more as a crack sound, but I could hear it from 3/4 of a mile all the way back to the 1/10 of a mile.
In 14 years, no bass fisherman's ever come to TBI and said, I heard a gunshot on April 13th, 2011 at the river. Have they?
Yes, sir, they have.
Who?
A man named Mitchell Hayes.
And why didn't he testify?
because he didn't come forward until after the trial.
And was this information?
Mind you, the trial took place in 2017. This incident occurred in 2011. So it was at least 6 years later, this person had an epiphany and realized they were out there on that specific day at that specific time and remembered they heard gunfire. I'm calling bovine scatology on that. I don't believe it for a hot second. I think that is craziness, crazy talk. All right, let me get us pulled up to the next person here. So the next individual, I have to say, when I saw that in the hearing, it was pretty telling to me. And I know she ended up having some complaints of, well, you know, we don't know how many leaves are on the trees, and it was a different time of year. It really wasn't. April 13th, and they did this test May 6th. That's a 2-week difference. Trust me, I used to live in Tennessee. You're not going to have a ton of leaves on the trees in mid-April or beginning of May. You're just not yet. It's still spring. And we don't know, how much traffic there would have been. Ma'am, it was like 10 o'clock in the morning, supposedly, when this happened. And it was a weekday. So I'm thinking the traffic was probably a little lighter in the middle of the morning than it would be on a weekend or something. So, so frustrating. Yeah, and exactly, Kelly. Dude would have known way before 2017 about this and been like, wow, I need to go tell somebody immediately. It's, yeah, whatever. I'm not buying it at all. So the next one that we are going to watch is Mr. Paul Hagerman. He was I think assistant DA to Jennifer Nichols on this particular case. I do happen to know that he did the opening statement and he just about whispered to the jury. So we're going to watch him now.
State your name, sir, and spell your last name.
My name is Paul Hagerman, Hagerman.
And what do you do for a living, sir?
I'm an assistant district attorney
What district?
in the 30th Judicial District at Memphis.
And how long have you held that post?
24 years.
You were a prosecutor in the prosecution of Zach Adams, Dylan Adams, and Jason Autry.
Yes, sir.
And when did you come on the case?
Not sure about dates. The case had been going on for a little bit. Jennifer Nichols and Ray Lapone were on the case, and Ray had recently taken another job and gotten off the case. Ms. Nichols got Mr. Ragland, Mr. Christensen, and then me to help her on the case after that.
Did y'all have a specific assignments?
No. Ms. Nichols and myself we were the primary attorneys that worked on it the most.
Okay. Was the case a death penalty case when you came on?
Yes.
And when you came on, had you reviewed the 2014 recorded statement of Dylan Adams?
After I came on, I reviewed it, yes.
Okay. And at some point, you received cell phone records of the defendants in this case?
TBI or the other investigative agencies had gotten cell phone records for the defendants. That was part of the file.
Okay. When did you realize Dylan's statement was impossible with the cell records?
So when I first got on the case, of course, Dylan's statement already existed. It was recorded. It wasn't until Mr. Autry gave his proffer that we realized the significance of a lot of the cell phone proof. So maybe, I guess that's my answer to that, unless there's a more particular question about what you mean.
You realized Dylan's statement could not be true.
Based on the cell phone proof?
Yes, sir.
Yeah.
I wouldn't say that. I wouldn't say I realized that.
Clearly.
Well, I don't know that they can be reconciled.
What do you mean by that?
Okay. I mean, Dylan's statement was, I want to say, it's limited because it does go on for a decent amount of time, but it doesn't provide details as to exactly when and where and every party's movement, during the incident, or after the abduction and pre-abduction, and then during.
Really?
You remember reviewing Dennis Benjamin's statement that Dylan gave to him that became the precursor to the recorded interview?
Yes.
Okay, let me fill in some blanks for you. Dennis Benjamin is a retired law enforcement individual. He volunteered once Dylan Adams agreed to a plea of sorts. I'm sorry, no, they all agreed to have Dylan taken into custody for this crime. And instead of him being behind bars, this Dennis Benjamin person, retired law enforcement, came forward and said, he can come live with me. And after 5 weeks' time of living with Dennis Benjamin, poof, Dylan Adams has a full confession of exactly what happened to Holly Bobo. So that's who Dennis Benjamin is, just to give you a background on this.
The witness can be passed. Exhibit 104.
Next slide.
You have the front.
I do.
And can you go to page 3?
Remember, we kept the IR on the front, so it's page 3 of the handwritten portion?
No, sir, of the type.
Okay.
I've got 1, to the back is 2,
And then 3.
and then 3.
Yes, and
Gotcha.
you see Dylan's timeline. John Adams' timeline.
Okay.
You remember looking at this?
Yeah, this is one of almost thousands of IRs that I would have reviewed. Absolutely.
The timeline of arrival 9:30 to 10 a.m.
I see that on this IR, yes.
10:05 to 10:50, Autry raping Bobo.
Okay.
Do you remember the evidence y'all submitted to the jury about where Mr. Autry was during that time frame?
Yes.
Where was he?
I remember Mr. Autry's testimony from the trial, and then I remember cell phone records with regard to Mr. Zach Adams and Mr. Autry's whereabouts during this time frame.
And what?
Remember that time, 10:05 to 10:50 is when an essay is occurring by Zach Adams on Holly Bobo. That's going to be important as we carry on.
Or what are they?
Which time are you asking about?
Between 10:05 and 10:50 a.m.
I can't say now, years later exactly, but I would think that would be about the time that they would be getting back from the river or in their travels.
These are two totally inconsistent realities.
You asking? I think this is a summary of what Dylan Adams would have said in his statement.
Right.
Yeah, and if he got things wrong, then absolutely he got things wrong. But Mr. Dylan's Adams statement does not match Mr. Autry's statement. If that's the question.
Not by a long
From
shot.
10:50 to 11:10, John Adams raping Bobo. 11:10 to 11:55, Zach Adams raping Bobo. Are you aware where the cell phone records put these defendants during that time frame?
Again, we're talking years later here. And so from my memory, the abduction is around 8 in the morning. Rape, travel to the river, come back. And from my memory, comeback time would probably be around 10:50 or something. I don't know if in particular.
Let me
Oh,
ask you this.
boy.
Do you remember a moment when you realized this Dylan Adams story doesn't make sense?
I remember watching Dylan's statement on video recording. I remember speaking to Mr. Dylan Adams, and I remember thinking that he is not telling the truth about what happened, and his details with regard to what happened, are insufficient, incomplete, held back. That his statement was incomplete, if that's what you mean.
When you say insufficient, do you mean insufficient to get a conviction?
Against whom?
Zach Adams, Jason Autry.
You wouldn't want
Sir.
Dylan's statement to be the only piece of evidence in front of the jury. You would need at that time too corroboration under the law. And so if you're actually asking about Mr. Adams and Dylan's statement, you could build a case against Mr. Adams, which you could win with Dylan's statement being part of it, because there was other proof against Mr. Adams.
But if he said a series of events that were impossible to be true, that's concerning to you, isn't it?
Absolutely. And that's why I said when I watched the statement and talked to him, I thought there were details that were wrong. I think he was holding a lot back and not telling.
And at the time Dylan gave his statement, he did not have the cell phone records.
Yeah, I assume he did not.
When Jason Autry did in early 2017, he had the cell phone records, correct?
I was told that Jason Autry himself did not have the cell phone records.
Who told you that?
Mr. Scholl.
Okay. We'll come back to Mr. Scholl. Do you remember an extra copy of the cell phone record going to Mr. Scholl in November of 2016?
I wouldn't have remembered it, but when I was looking over stuff to prepare, I saw that.
Okay.
Or I was told about that.
That's out of the ordinary.
No, it's not.
It's not. Why is it not?
Well, with cell phone records, it's quite often the case that the original form in which we provide them is not what the defense's expert wants. So providing the cell phone records in a different form later on happens all the time in cases like this.
So when did Mr. Scholl tell you Jason doesn't have his cell phone records?
As when we first approached that defense team about the possibility of Mr. Autry cooperating or testifying, some time passed between then and when he actually came in and gave the proffer. Mr. Scholl told me during that time period that Jason had told him the whole story, had given the whole account, but that Mr. Scholl and his investigator wanted to check things out. They wanted to see it conformed with reality. And one of their big truth tests of Mr. Autry was the fact that he did not have the cell phone records, and they looked at his story, compared them to cell phone records, and that added some credibility to Mr. Autry.
Sure.
At this time, Mr. Scholl made public comments that Mr. Autry had nothing to do with the rape, kidnapping, and murder of Holly Bobo, correct?
Do not know.
You remember him on the news saying that on the lawn at Decatur County Courthouse?
I did not watch the news.
He
Do you
sure
remember
did.
his motion to continue in August of 2016 saying, I try to go and take my discovery to my client. The jail confiscates what I bring to him. I don't have a place to set up my laptop. There's voluminous terabytes of discovery to go over. And I'm not prepared to try this case in whenever the trial was set.
I don't know if I was on the case yet, but that sounds familiar.
You were on the case in August of 2016, correct?
Yes.
And so when did the conversation where Mr. Scholl now has been able to go through all this discovery, he said he hadn't gone through in August of 2016. When did he tell you?
So if you go, I do not know a date for you, but if you go to Mr. Autry's proffer agreement, it would be some time period within a month or two before that.
Okay.
Okay. We're going to continue with Mr. Hagerman. I just have to get things queued up for you. There's more clips with him. Bear with me just a moment while I get my life sort of in order. Oh my, I don't know what just happened here. Okay, now I'm back to where I need to be.
Offers of leniency in 8 years' time served.
Okay. All righty, give me just a second. I want to get your closed captions on. And here we go with more from Mr. Hagerman.
Just to orient you, General Hagerman, the Bobo residence here in the bottom crown. The remains found up here.
By the cell tower.
Correct. Tower 10961. There's no movement from 826 to 856 on Holly's phone. Shane house here on sector 31523. Zach's home on 31522.
Okay. So to answer your question, I think that there was evidence. There were various items that had been discarded, note cards and things north of Swan Johnson because it was in proximity to Shane's house.
And if the travel was clockwise from the Bobo residence to where the remains were down to the last cell phone ping on Gooch Creek at 925 on tower 12573, that direction of travel, there was no evidence before the remains and physical evidence thrown out after, right?
I don't understand. I'm sorry. So the incident occurs on Swan Johnson.
Correct.
Okay. And there is evidence north of Swan
And you
Johnson.
just look on Exhibit 5 to show the various pings on the cell phone route. 811, 816, then 826 to 856. Follow me?
Yeah, so the purple note cards
Correct.
are going to be some type of cell phone location that's not a GPS ping, but is some sort of middle of the circle, I assume, having to do with the proximate location.
Correct.
I hope, trust is love, that when you say this attorney is awesome, you're talking about Mr. Bates, the defense attorney for Zach Adams. Although Mr. Hagerman seems to be the least shady that I can tell from everybody, I do have quite an affinity to Mr. Bates. Yes, that is the case. Well, good. Yes, we're all on the same page. Yeah, I think he's working his tail off. I love how he pays attention to detail. He stays very calm, cool, and collected. And you're going to see patients get tested coming up.
And you understand that's what Marshall Walker, what he found in his work.
Which is what?
These pings along this route of Miss Bobo that morning up to this location where her remains were found.
I understand that he made this map, and I understand that the purple things on this exhibit have to do with cell phone location. It's not a GPS ping, so we're not talking about a coordinate. These notes should actually be large circles that cover a certain
Right.
circle. I have no idea how big circles are.
You would agree then it's consistent with his work y'all call speculation that her remains were found where he said the remains were going to be found.
Yeah, I don't remember the part about.
And a bullet round, a spent casing was found right next to Miss Bobo's remains and personal effects.
I remember there being a casing that was found in proximity. Yes,
And it's a .38, a 38 auto round.
that
Right.
sounds familiar.
At any time, did you Google what the actual size of a .380 pistol round is?
We had conversations with people that
Who's we?
did ballistics,
Who is we?
the prosecutors,
Okay.
and then ultimately we had a meeting with Dr. Ross, medical examiner, who opined about the size of the wound and what type of caliber could make that.
And he says it was anything no bigger in size than .36, right?
I don't remember.
Are you aware that a .380 is not .38 in size?
I do not know. I mean,
At any time did you say, Dr. Ross, thank you for your service to the state. Can you tell us, is the round next to the remains that verifies possibly now Marshall Walker was correct and the direction of travel was clockwise, is that round larger in reality than .36?
I don't remember asking him that. He was Mr. Christensen's witness, but obviously I would have been familiar with the entire case. We definitely talked with Dr. Ross about what caliber be consistent with the wound, that he found.
Okay.
And then he offered his sort of expert opinion with regard to that.
Where in your professional opinion was the body and Miss Holly's body and her cell phone separated?
I'll have a professional opinion about that, but you've heard or you've read or seen Mr. Autry's testimony, and you've heard the proof about the cell phone records, so you could extrapolate, from that.
You told the jury something. I'm asking you, where was it separated?
You mean a physical location where it was separated?
When
Yeah.
and where was the body and cell phone separated?
Well, we believe that when Mr. Autry and Mr. Adams traveled to the river with Miss Bobo, that the cell phone was not there, that she was separate from her cell phone, and we believe that Mr. Dylan Adams was probably the one that had the cell phone thereafter.
Have you gone through and reconciled the timeline Mr. Autry testified as to when he showed up at Shane Austin's house?
Yeah, we did. We spent a good amount of time looking after Mr. Autry gave his account at what evidence corroborated,
Right.
His account.
What time does Autry say he gets to Shane's house?
I can't tell you. You'd have to look at the record there. I can't remember that.
Just take a moment. Did you ever remember somebody saying, wait a minute, we got a problem? Autry and Zach talked that morning at 8:52 a.m. and we got it on the cell phone record.
Problem with the timeline.
We looked at Mr. Autry's records and looked at Mr. Adams' records,
You remember a phone call at 8:52 a.m.
not the particular time.
Do you remember if Zach was at his home tower at 8:52 when that phone call went out?
I do not remember.
Do you remember saying, oh no, Holly's cell phone and her body are on 10961? We got a problem.
I do
Yeah.
not remember that being a problem.
Do you remember Audrey testifying it was 20 to 30 minutes after the 8:52 phone call, which puts it at the very earliest at 9:12, the latest at 9:22, when Audrey appears at Adam's house? Do you remember that?
Not the time.
Do you remember if it was at 9:20, if it was at 9:17, 9:15? Audrey says Dylan is standing in his shirt off inside the trailer. Do you remember that?
The trailer. Do you mean Mr. Austin's house?
Yes, sir.
I remember. I don't remember the time, but I remember Mr. Autry describing when he arrived and Mr. Adams being there, Mr. Dylan Adams, without a shirt.
And that time, Holly's cell phone is traveling from 9:10 down to 9:25 at Gooch Creek.
Oops.
Somebody's lying.
Well, again, I don't remember the times, but also what we have to take into account when we look at these things is we got different
Doesn't
actors,
work.
right? So this idea that Mr. Adams, Mr. Autry, Mr. Dylan Adams, and Mr. Shane Austin are together the whole time is just not, that's just not correct.
Right, but you told the jury it was Dylan moving the cell phone.
Yeah.
When Jason says Dylan is sitting in his trailer with his shirt off and never left.
Again,
Yep.
I don't remember the times, and I think you have to take into account that we're talking about circles and not pinpoint GPSs. I remember also the expert cell phone testimony having to do with bleed over between Zach's home tower and
No doubt.
one of the other towers.
Right, 31523 and 31522, sometimes you can ping off both, but not 12573 where the phone was found. I'm sorry, where the lunchbox was found and other things.
That's the problem. Yes, you have little circles, sure. But if I've got a circle here and I've got a circle here, there's no bleed over. It's pretty easy to figure out. These cannot be this. You can't be at the same place. Oh, it's so infuriating. And I want all of you to remember all of the memory issues, because when we watch this trial, y'all know we're going to be paying attention to what actually gets said, because we're going to have a little bit of hindsight, which I'm actually glad we're doing it this way.
I don't remember.
Okay. Now, you did not take part in the Jason Autry proffer session, did you? Or
I
did
did,
you? Okay.
absolutely.
Did you take notes?
No.
Why not?
I don't take notes.
You don't take notes.
I don't.
You take notes during trial?
I don't.
Okay, fair enough. Was it a policy not to take notes during proffer sessions?
Absolutely not.
When, if ever, did a TB officer come to you and say, I think Jason Autry's lying?
No TBI officer came to me and said that.
Are you aware of a TB officer coming to any prosecutor and saying that?
I'm not. I'm aware of ex-TBI Dicus that I went to talk to, but
What about Kathy Ferguson?
no, I'm not aware of that.
If she did, it would have been significant to you, wouldn't it?
It would have depended on what we're talking about, but it potentially could be significant, yes.
Now, at some point, did you come to the conclusion, we're going to lose this case if Dylan's our witness?
No, but Miss Nichols and I, like I said, believed that Dylan was leaving a whole lot out and holding back, and we weren't entirely comfortable with him being a primary part of the case. We were much more interested in a cooperator that would tell the truth and give a truthful account.
No, you wanted somebody that was going to match your
At
narrative.
some point, did you listen to Brent Booth in Indiana talking with Victor Dinsmore?
I did not.
Okay.
I think Miss Nichols had, and she relayed to me sort of generally.
Did Miss Nichols bring up concerns to you about that conversation?
I remember this. I do remember that she wasn't impressed with the interview.
On Agent Booth's behalf or Victor Dinsmore's?
Can't remember. Really can't remember. I think that we had higher hopes for like what would be disclosed in the interview, and that didn't happen.
Let me fill in some more blanks for you. Victor Dinsmore is a friend of Zach Adams' family. He was keeping a vehicle for Zach Adams' grandfather because Zach Adams' grandfather did not want Zach to be driving this vehicle. So he hid it at Victor Dinsmore's house. So, and that's going to become more important as we head on down the road as well. So, and yes, a little Dever-like. Never Dever. Never Dever.
Have you listened to this since the trial? Did you listen to it before the trial?
No, I didn't. Like I said, I think I'm going on third party summary of it.
When you say not impressed, I take that to mean you, as a lawyer, you wish it would have been better evidence at trial.
I don't know if we ever contemplated it being evidence at trial, but I remember when he went to interview him, we had high hopes that Dinsmore had more information and we were going to get it as a result of the interview.
Do you remember, did Miss Nichols say, I'm a little concerned Agent Booth suborned perjury?
No, but not being impressed with the interview, she may, I don't want to guess, she may have made comments about she didn't like the way he asked questions or something like that.
As a prosecutor,
I bet
before
she
trial,
did.
Do you think it's ethical for you to go to one witness who's going to testify to something, go to another witness and say, look, this is what this witness is going to say, and I'm trying to get these details lined up, and it helped me and it helped this case if you said this?
You don't want to ask for a witness not to tell the truth, right? And you don't want to feed a witness information. A lot of times it is helpful to confront a witness with facts that you do know in hopes that person is then going to tell the truth. So it's a sort of mixed answer there.
Okay. At some point now, who approaches whom? You or Mike Scholl regarding Jason Autry testifying?
So to testify or to sit down and tell us what happened?
Whatever came first.
So there was another time that we were in Nashville. We went to Nashville several times. Discovery conference I mentioned. After the Discovery conference, at least once, maybe more than once, we met in Nashville to look at the evidence with the defense attorneys.
Okay. I got to take us to the next spot here. So bear with me while I get us queued up. Oh, what am I doing here? All right.
That Dylan was quote unquote the state's witness, but nobody committed to that or anything like that.
So was the state prepared to request Mr. Autry serve 50 years? When Mr. Scholl and you were discussing Mr. Paris, y'all very well could have asked for 50 years.
No, no, Jack, this sounds like speculation.
It goes right to the
What
heart.
about numbers?
This is a pled allegation in our complaint.
This is in reference to what kind of deal Jason Autry was going to get for his testimony. That's what all of this questioning is now in reference to.
This is, if the state did not disclose this, what became reality, but the difference between offers of leniency and 8 years time served.
Anything else?
No.
All right. There's no rule. I'll
Did
I
the
like
state
this,
have internal
Judge.
discussions about what it would be willing to do to Mr. Autry?
Internal, me and Ms. Nichols and Mr. Christian, Mr. Ragland. Yes.
And what were y'all prepared to do?
Well, after we heard Mr. Autry's account and after we saw the corroborating evidence, we believe that Mr. Autry was telling the truth. On the other side of the equation was that the state's case against Mr. Autry was quite weak at that time.
That's
And
the
so
real
Ms.
problem.
Nichols and I and Mr. Ragland and Mr. Christensen all talked and knew that at the end of the day, we were obligated to take into account that the state's case against Mr. Autry was quite weak and that his account was the most truthful, most detailed, and most corroborated account of what happened and assisted in the prosecution of this defendant, Mr. Dylan Adams, more than sort of any other single piece of evidence we had. And so we knew that meant that Mr. Autry, at the end of the day, again, this wasn't communicated to defense, but at the end of the day, we weren't going to get much more time out of Mr. Autry.
Then time served.
I can't say that we talked about time served. I can absolutely say that we talked in terms of we're not going to be able to get much more time out of him.
He was given
Was that
time
ever
served.
communicated to Ms. Thompson?
Those internal thoughts that we have?
Yes.
No.
Why not?
What was communicated to Mr. Thompson was that the truthful testimony of Mr. Autry was going to be taken into consideration at the end of the day.
But y'all held the keys to the secret, which meant that means time, virtually very little more jail time.
We knew that that was what we had against Mr. Autry was, here, and what Mr. Autry was providing for us was here. And so we talked about these things internally because we have to make a decision as to whether or not to use Mr. Autry as a witness, or not. So obviously we have to talk about these things. We would never convey that to Mr. Autry or to Mr. Scholl or Mr. Paris without telling the defense and the court, because that's what we have to do, because that would go to motive and bias. Since these were internal discussions, it couldn't possibly go to any sort of motive to lie or any sort of bias. At the end of the day, we have to do what's fair. His truthful testimony deserves some credit. At the time we made the decision, our case against Mr. Autry was very weak.
Wow. We had a really crappy case against Jason Autry, so we just kind of let him tell us whatever we wanted to hear, and he did. And so we just headed on down the road. For the love of all things holy, can you believe this? This is a mess. I gotta say, sadly, Massachusetts doesn't have a corner on the market for corruption and craziness in a courtroom, sadly. Okay, I'm going to need everybody to take a huge deep breath, because we are going to have the spicy that I have been telling you. It's going to get really spicy, and y'all are going to be mad. And make sure you've got your antacids ready, because this is going to be, as they would say, as Matt McCabe would say, this is going to be an episode. I just need y'all to understand that. Okay, so the individual that is going to be testifying now is Jennifer Nichols. She was the lead prosecutor on this case that prosecuted Zachary Adams. She is currently a judge. I want you all to remember that. She was not elected. I got to back up. She was appointed to be a judge back in 2018. That same year, she was up for re-election and she was not elected. She then was that appointment was by Governor Haslam. Then she was reappointed last year to become a judge by Governor Bill Lee. The Bills, man, the Bills. So I say all of that because it's going to be important as you watch this testimony to keep that in mind. And Kelly, yes, she is the one who threatened to punch the defense attorney. Oh, y'all are going to be really excited to watch this trial, knowing what we know now. So I'm going to try to refrain from a lot of comments, but you know how I am.
And Mr. Dinsmore admits that he threw a 32 away unrelated to the Bobo case, right?
I was having trouble hearing some. I heard him talk about a 32 and I couldn't hear what he did with it.
Okay, we'll play it again. Which gun did you not hear?
I heard him say something about a 32 at the end of the interview, but I couldn't hear what he said he did with it or what happened to it.
No problem.
Also, anytime you're able to see the judge, pay attention to that as well. I find it fascinating, his demeanor at certain times and when he takes notes and when he doesn't. That's all I'll say.
I heard him call it a junkie gun.
When we got off them, I traded for them bills. I had her start, and I remember.
Yes, John.
You get rid of the guy, you make that a lot of money. Because they bring that hands on. And I remember when I both guys about the other guy was the junkie little piece of shit there too. I get myself on through that in my cousin's car. Okay, because I was a Brady blocker.
Junkie piece of blank 32. I took it and I threw it in my cousin's pond.
Okay.
You heard that?
But I heard if that's what it says, I'm not disputing it. I'm having it's breaking up. I heard he threw it. This time I caught that. So I want to just trust you, Mr. Bates. That's what it says.
And you know who the cousin was?
No.
You know where?
I don't know who the cousin was.
The Bowens.
I don't know who the cousin was.
Fair. Okay. So now I've given you the life cycle of this gun. The 22 rifle, IR 1929, the Dennis Benjamin's 22, to a 357, to a 38 interchangeable barrel with a 357. Why did you refer to it as the murder weapon of a 32 revolver? Mr. Dinsmore told you I had a junky piece of blank 32 that I threw in the water. It's in a pond. It never dawned on you. I think that's the 32 he's talking about.
No.
Why not?
Because it's not what the proof was.
What was the proof?
That,
The other statement
excuse me,
was-
did you ask me a question or do you not want me to answer it?
I want you to answer.
Great. The proof was that he traded drugs for the gun. He was nervous about the gun. He gave it to his wife. His wife, I think, was later told there could be a body on it, and she put it over here. And we went and looked for it. And that was the gun that was supposed to have been used.
Does it concern you, prior to pulling the 32 revolver out, that every other statement before this, a murder weapon was something different than the 32 revolver?
No.
It doesn't give you pause.
It did not give me cause.
During the prosecution,
Sir, I said no. My answer is not going to change. No matter how much you yell at me or no matter how much you argue with me, I believe we found the murdered weapon.
and that's the manner in which you prosecuted this case, right?
I don't even understand that question. That's the manner that I prosecuted this case. So I guess I would say yes. I believe that Zach Adams kidnapped, raped, and murdered Holly Bobo. He was prosecuted for it. A jury heard days and days and days of proof, and they found him guilty, not me.
Jenny, I have to completely disagree. Oh, I'm sorry. I misread this. She's anything but professional. I thought you were saying she's has an attitude, but she's professional. No, I find her anything but professional, just like you have. I'm so sorry. I'm just gonna. It's Monday.
Your closing argument, page 2,733, line 21.
Am I supposed to find that page?
I'll read it for you. there was some discussions about the measurements of the ammunition. Marco Ross told you the exact measurements of the hole in Holly's skull as compared to the measurements of a .32 caliber. And then, bless his heart, the defense witness that came in with pictures of different calibers, I have no doubt that the way he measured them is the way he reported it, but he didn't know how to measure them. Didn't know that remove the projectile from the casing and then measurement. So the expert who testified about that gunshot wound to Holly's head said it matched my words perfectly, basically those measurements, and you remember his testimony, it excluded a .38, excluded it. Do you remember giving that part of your closing argument?
I do not.
All right.
As I said, I don't remember my closing argument. I've never gone back and read it, and nor have I ever gone back and listened to it.
You were the attorney in this case when the post-conviction filing brought this up.
I was.
Did it jog your memory to go back to the transcript and read it?
Are you asking me whether I actually did read it and I'm not willing to admit it?
Oh,
Because
I'm
I told
asking you what I
Mr. Bates, I did not read it.
Okay. But you were on notice this is an issue.
Honestly, I don't remember what notice I had about various issues. There were several that stood out in my mind.
And one of them was that you misstated
No.
the diameter of a .38.
I was never worried about misstating it because you're incorrect.
Okay. Well, what is the diameter of a .38?
I am not,
Sorry, 380 auto round.
Mr. Bates, you are wasting your time if you start asking me about various diameters.
Don't argue with Mr. Bates.
I don't know.
Did you hear
I
the
don't know-
judge?
I know what the expert said. I know what Marco Ross said
Well,
about the defect in her head,
Right,
her
but
skull.
how many hundreds of thousands or millions of dollars did the state of Tennessee have at disposal in prosecuting Zach Adams?
I have no idea.
A lot of money.
The most ever in the
Is that a
state's
question if the
history.
state had that much money?
Yes, it is.
I don't know how much money they had to spend on it.
All right. Did anybody say, hey, how about we buy a micrometer and measure what a 380 auto round is, like the one found next to Holly's remains?
I don't know if anybody said that or not.
Did anybody, including you, go to www.google and see what various sites said?
I don't know what anybody did.
Well, then how did you say .38, which is the exact caliber of the bullet found by Miss Holly's remains, was excluded?
Okay. Marco Ross, who was the person who performed the autopsy a second time on Holly's remains. Unlike me, he measured, he knew and testified to the measurements of the defect. And he said, any caliber of gun, this level could have made the defect. Any caliber of gun larger than that could not have.
Are you familiar that a 380 round is not in size .38?
No, I'm not. I said a minute ago, I am not a ballistics expert.
This is a big deal.
Do you stand by what you said at closing argument?
Yes.
Wow. Wow. Knowing full well it does not compute. The math ain't mathin', y'all. You better keep sucking that water down, honey. Yeah, she's trying to get her lies straight, and she's also trying to intimidate. And Mr. Bates ain't biting. Mr. Bowtie Bates, love
Were you
him.
in charge of the reward money getting to various witnesses?
No.
Did you have any part of that?
No.
Do you have any awareness of that?
No.
Oh, y'all, it gets better.
Were you prepared to prosecute Jason Autry for the death penalty?
Well, you mean instead of Zach, or like that day, or like how?
At any time were you prepared to prosecute Jason
We were
Autry
prepared to go forward.
and prosecute him for death?
We were not. You don't prosecute someone for the death penalty. You prosecute someone for murder in the first degree. The jury has three choices: death penalty, life without parole, and life.
And you filed aggravating statements, correct? Aggravating circumstances to justify.
Is that aggravating factors?
Yes, sir.
She doesn't need a Diet Coke and a cigarette. Based on what I'm seeing here, she needs a big, stiff drink. I think that Ms. Nichols here likes to partake.
Just like I don't remember. Of course, we filed one. I don't remember filing it or what date it was filed on.
122.
I certainly recognize my signature at the end of the filing. I haven't read the filing. It says June 3rd, 2015, which makes sense.
If you could just take a moment and read it, please.
While you're doing that, let me correct that. This is not in this record. This is the notice of aggravated circumstances, State versus Geneva, Jason Autry's case. So it's exhibit 122 this time.
She spends a lot of time shuffling papers up there, so.
Relevance of the aggravated,
Evidence did you have to justify these of Jason Autry?
can I object to the relevance of the aggravated circumstances notice filed against a co-defendant?
All right, the objection is relevant, Mr. Davis.
Yes, Your Honor. I believe this is relevant and ineffective assistance to counsel to have brought out to show Mr. Autry's bias, as well as whether the state on the Brady violations part of the petition and other parts of the evidence.
I think it fits under the IAC claim, so I'll let you present this.
So what was your question?
What evidence did you have that Mr. Autry?
Okay.
For
So
instance-
number 2, Mr. Autry had one or more felonies. And I don't have it with me. I assume you have his record. We had his record. Number 5, the murder was especially heinous, atrocious, or cruel, and that involved torture or serious physical abuse beyond that necessary to produce death.
Let's stop there. What evidence did you have that Mr. Autry committed this crime?
You're familiar with, the premise that if you, criminal responsibility, you know that, correct?
Just answer the question.
Well,
I am.
criminal responsibility for one thing. So if he didn't do it himself, we had,
Take out criminal responsibility.
I know, because you asked me what I had. That's what I had. I'm not going to take it out
So what evidence did you have that Mr. Autry was criminally responsible for somebody else's actions?
because they were together. Everybody said they were together. Their names were mentioned immediately. Their names were mentioned.
So you still
With
have to prove it,
all due
ma'am.
respect to TBI, because I have a great deal of respect for the officers who, in the end, worked this case. But they went in a direction and ignored what was right in front of their face. And if you go back and you had, you're asking me about Audrey. The person I tried was Zach Adams. We had Zach Adams confessing in detail to several people, making short confessions to half a dozen others. We had a lot of proof.
Jason Autry. You had statements that later.
And I began this with they were together. Okay. Whoever ended up doing one thing or the other, they were criminally responsible for each other's actions. That's what the law says. That's not Jennifer Nichols.
Trust is love. This is not the Jennifer that complained it was too hot. We haven't gotten there yet. That is coming up. Wrong Jennifer. This is the prosecuting attorney, Jennifer.
So fair to say you had no evidence, in your opinion, when you filed this, that Jason Autry is the one.
I'm going to object. That's not what she's saying.
I'll let him ask the question. She can clarify this.
You had no evidence when you filed this in June 3rd, 2015, that Jason Autry was the one who raped Ms. Bobo, who murdered Ms. Bobo.
No, I'm not ever going to agree with that.
Okay, then tell me what evidence it was.
You know what? We have a fundamental problem because there are 250,000 pages. I can assure you that when you asked me earlier about the process we followed, we had to present to the DA what we had for every single aggravator that we were using. We just did. You didn't just go in there and check one. Okay. I don't remember the dates that we found out everything. But, excuse me. Thank you. But we knew Holly had been kidnapped, hit right outside her back door. Her blood was spattered. We knew they got her out of there. We knew that they traveled up and down. We knew where they went. She was killed. Her remains have been found. She has unfortunately, a bullet to the back of her head. Even though we didn't believe everything that Dylan said, we had Dylan admitting that they raped her. We did believe that. We thought he minimized his responsibility, that nobody can make you rape somebody. But we had a lot of proof. I will say this, Autry's case was probably the weakest of the three. Because
She
he
had
didn't
nothing.
talk.
You had nothing.
At the time, he wasn't telling people different things.
So you didn't believe Dylan's video until you didn't.
Not what it said.
You said Dylan's statement said this, but we didn't believe it.
Right.
So
You didn't ask me what parts.
you think part of Dylan's statement was true?
Yes.
Well, earlier this morning, you didn't say part. You said I didn't believe it.
No, you didn't ask me to clarify. I'm trying to answer. Nope.
I asked you the video. Did you watch the video? Yes. And I didn't believe it. Do you acknowledge that was your testimony this morning? Yeah. Okay. You didn't say there were some things I didn't believe. You said I didn't believe the entire, you didn't believe the video.
I'm not going to play semantics. I said what I said.
You think I'm playing semantics?
I do.
Okay.
I do.
Yo. I want to smack her. I literally want to drive to Tennessee and smack her Oh my gosh, I get so enraged with this woman. And I had to do it in this order because we're now going to see Zach Adams, defense attorney, and there's a lot here, but I feel like it's important that you all see what her perspective was on this case, because it fills in a lot of the blanks as far as, well, I mean, kind of why
You didn't ask Agent Booth. if he
Zach
felt-
didn't get a fair trial. Oh, yeah, she's a piece of work. You are not kidding. My blood pressure, I was like, oh, I don't know how Mr. Bates kept it together. I don't know how he did it. This is not in front of a jury, but it's in front of a judge, and she's a judge. Ma'am, do you have no professional respect for the courtroom that you sit in? Oh my goodness. I was absolutely blown away at her behavior. Absolutely blown away. All right, let me get us going here on oh no. Why can't I find, oh, it's an hour in. All right, bear with me. And no, Kelly, she's not concerned about the judge. She's not concerned about anything. Yes, mind blown and zero respect. She is the smartest person in the room. She knows everything. It's awful. It's absolutely awful. Okay, I'm going to get us connected here. This is Jennifer Thompson. And she is the defense attorney that represented Zach Adams in his actual trial. When we rewatch the trial, she'll look very, very different. But I want you to pay attention to her testimony because I find her very credible in how she. Let me
Still
get
trying to
us
go
going.
through all and such a change, a big copy it on that spring.
Why?
I begged Jerry Gonzalez and he said, okay.
Jury selection began in July.
Was it July or April? I can't remember, but jury selection began well before trial.
And who performed voir dire?
I did most of the voir dire. I did most of the beginning voir dire. And then at some point, the judge had yelled at me so much, I refused to get up and do anymore. And I made Jim get up and do it. The judge, one of the witnesses was crying. And I said, I'd like the record. One of the potential jurors was crying. She was on the stand and she was so bothered by the taking of Holly Bobo, she began to cry. And I said, I'd like the record to reflect that the juror is crying. And the judge snapped at me and said, I'm sitting right here next to her. Her voice is cracking, something like her voice is cracking, but she is not crying. She was crying. And he snapped at me so much. I just, at that point, I gave up and I didn't want to do any more voir dire.
How would you assess your mental health at this point?
And at one point, Jim Simmons wasn't even there for part of the voir dire. He had another case in another county and the judge insisted we go on without him. So at some point, Zach had only one attorney present. My mental health was declining.
Did you consider withdrawing at this point?
I didn't because I felt that because of the mess with Luke Evans and Luke being so eager to try the case and to really work on the case tough, I felt that if I withdrew, that the judge was just going to point somebody that he knew that was going to just take this case and plead it out. Because Jim Simmons had tried very hard to get Zach Adams to plead guilty. And he had come to me and said, on one occasion, he said, I've talked with Zach. He's ready to plead guilty.
Was Jim working on guilt innocence?
No, he was not working on guilt innocence.
And did Mr. Simmons file a motion to withdraw?
Well, Zach, after that, Zach told him he wanted him to withdraw. And Jim Simmons filed a motion to withdraw under seal where he said something to the effect that he believed the client was guilty and that withdrawing in the case would be detrimental. I couldn't believe that his affidavit said he thought that the client, something about the client's guilt or that evidence was overwhelming and that it would be detrimental to the client under the ABA standards to withdraw as attorney of record, something like that. And the judge didn't let him withdraw.
and the judge should have had him withdraw.
Your office then filed.
Okay. I meant to show another clip first, but that's okay. We're going to get to all of it. And Georgia Hello Kitty, you're asking me what happened to the judge in this particular case. He retired. He retired, as he probably should have, because things were not going to end well, I don't think. Okay, here we go. Next clip. Yeah, I'll just.
Yes, sir. Thank you. You were present in the fall of 2016 when there was a series of motions before the court. Do you remember that?
Yes.
And there was a motion to continue by Mr. Schultz.
Yes.
You remember what all motions you had before the court?
I don't remember.
Do you remember when trial was scheduled to start?
Easter.
Okay. And what was your takeaway from that motion hearing?
Well, I think the judge was very negative about everything that we wanted. I think that I just got the feeling that the judge wasn't going to rule in our favor on things.
At some point, you attempted to bring in Luke Evans.
Yes.
When was that?
That was in February, I think, of 2017.
Okay.
That was very disheartening.
What took place in between the motion hearing in the fall of 2016 and February of 2017?
Well, Jason then had flipped and had made up this whole story about he was with Zach when Zach shot Holly Bobo.
Mr. Scholl called you and talked to you about this.
Yes, he called. So I was downtown Nashville. They were having the little rally downtown Nashville for women. And I was in downtown Nashville with my family and my phone. And I got a call. I think I got a call from Jim Simmons. But then Jim, I can't remember how it went, if we did a three-way call, but I was in a Jack's Barbecue down on 2nd Avenue. And I went outside upstairs to a balcony. It was cold. And I went out to the balcony to try to get some quiet so I could hear what they were saying.
And Mr. Scholl told you what?
That Jason was going to flip.
And did he outline?
He basically outlined the story.
Now let's put a pin right here. At this point in your representation of Mr. Adams, do you believe you were providing constitutionally effective counsel?
At this point, yes, but my heart sunk.
Okay. Why did your heart sink?
Well, because Dylan had already flipped. Jason was going to flip. And these guys were innocent. I just didn't understand why 3 guys or 2 other co-defendants that were innocent and had not committed this crime would flip to say that they did and put themselves somehow in this. It just stirred me to no end. It stirred me to no end that his attorneys were having him do this. I felt at this point, that the other attorneys did not really know the case. I had quit doing other work and I was doing this case only and was super absorbed in this case. I came down to Decatur County. I drove the roads that were in maps. I drove different roads. I went by different people's houses. I studied everything. I had been down here trying to get to know some of the people. I'd been involved with the family. I had completely immersed myself in this case. And the other attorneys were still doing other cases and weren't reading the evidence. They kept saying, well, why? I mean, he's guilty. Why doesn't he just plead? And they put in tremendous pressure on me to get Zach to plead guilty. I've never in my life had so much pressure put on me by other attorneys in the defense to have my client plead. This was the worst case that I've ever done, the most pressure that I had ever been under, and it was horrible. But I knew that Zach Adams did not kill that woman. He did not kidnap her, and he did not rape her. And I was going to stay in the case regardless of how they treated me, because I knew that justice needed to come forward.
You were in court in February.
Let me ask you a question. You just asked a question of the witness. At this stage, were you providing effective assistance to counsel in essence? Are you alleging that prior to this stage that she was not?
No.
So from here forward, is your IAC claim? From Mr. Autry's proffer and the telephone call from Simmons and Scholl informing Ms. Thompson.
Well, let me clarify. There are points prior to this that lead up to trial that are ineffective, as alleged.
I'll let you point those out close.
And there were, definitely.
Do you remember February 2017's motion hearing?
This is for Zach Adams or to have the judge recused?
Court's recusal.
Yes, I remember the court's recusal,
And did you have it transcribed?
probably, because we appealed it.
I love this judge. He makes me feel like somebody's in charge. He reminds me of the judge in the Ashley Benefield trial, if anyone watched that. Same sort of sensation I get. Like, it's all going to be okay. Judge has got it.
So it's at this point that Jim Simmons and I really severely parted ways.
Describe that.
Well, Jim Simmons did not want me to file a motion to recuse the judge
Why did you file it?
because the judge absolutely was biased in this case.
How is the judge treating you?
Since 2017.
It's shortly after this, they tried to put me in jail. So I would say they were treating me terribly.
How are they trying to put you in
Can you imagine?
Well, I had been going to the evidence reviews and I had been recording them. It was no secret. I had those little cameras that you used to put on everything. I've forgotten what they're called, but a little sport camera that you could set down and film. It had a wide angle view. A lot of sports people use them and put them on their helmets or their bikes or their motorcycles.
Oh, it gets better.
And I had one of these little cameras, and I wanted to go see, there were some items of evidence that were still in Jackson, Tennessee at the TBI headquarters there. And I wanted to go see these. None of the other attorneys wanted to go. Jim Simmons didn't want to go. I was the only one that went. And Jennifer Nichols was there and we were opening up different items. And I had the video camera sitting there on the table and it has a red light when it's on. It's on. I had been recording at the office, the TBI office in that summer in June when we went to the main TBI office in Nashville to look at the 500 items. And I'd been recording there. Everybody knew I was recording. So Jennifer Nichols at some point in the middle of this review said, "Are you recording this?" And I answered honestly, yes. And so she blew a gasket. She had a fit. She went out and got the head of the TBI office there in Jackson, came in and said, "How dare you record this?" Well, first of all, Zach had a right to see this if he had wanted to see any of this material. And I needed to remember what was there if something came up. So she came in and said, "How dare you record this?" And the TBI head of the office said, "How dare you record this? We have all kinds of cases in here. You're not allowed to record in here." Nobody had said I was not allowed, and I wasn't doing it secretly either. And so I stopped recording. I think we kind of stopped the evidence review at that point. And we went back to Nashville and Jennifer Nichols filed a motion saying that I had been surreptitiously recording things and that that she wanted me to be found guilty of this and to be put in jail. I think that's how I remember it.
And do you remember Mr. Scholl's conduct of this motion?
Oh, so we had this hearing back in the judge's chambers. He didn't have this hearing where the public could see.
Imagine
he took us all
that.
back into chambers, and Jennifer Nichols spews out. She's just so hateful and mean. She just spews out this tirade about how I've been secretly recording everybody and how this is against the law and how I need to be disbarred for this. And I can't remember. There's a transcript of it, but she's just pouring out this poison. And Mike Scholl and Robert Parrish got really, really upset, and they began to say, "Well, were you recording me? Did you record me?" And Jim Simmons took a step away from me. He was standing next to me. We were all standing up. He was standing next to me and he took a step away from me and said, "Your Honor, if they're trying to put her in jail, I think she needs counsel." Nobody ever said it's legal. It is legal. What I did was legal.
Did you ask them to point to the rule of professional conduct that says you can't record evidence to show your client a death penalty case? Did you say?
You know, at this point, I was so beaten down. Now I'm getting beaten down. I was so beaten down.
Can you help the court with the timing of this?
Well, this is after Jason has flipped and the case is going to go to trial. Right now we still have an Easter deadline for trial. And everybody is turning on me. At this point, Jim Simmons and I are not working together at all. We are not communicating hardly and we're not working together.
I'm going to ask you some personal questions now about your mental health.
Yes, my mental health is declining.
When did it start to turn?
Well, it started to turn early on when Jennifer Nichols came into the case. Jennifer Nichols is just so aggressive. Usually, even in criminal cases, I can be in the worst criminal case, but you talk to the DAs and they're polite to you outside of court. They're nice to you. You have nice chats and nobody takes it personally. Jennifer Nichols was hateful to me at all times. And
Do you believe her?
gone to a doctor and said, it's really bothering me. I'm really getting depressed because this case is bothering me. First of all, the TBI had been coercing witnesses, I think. And the state had been doing all kinds of wrong things. I've never in my life had a case where if I put my mind to it and I worked really hard, that I couldn't get a good outcome. And in this case, where I knew the facts were on my side, I could not get a good outcome. And I worked harder and harder and harder. And it just got worse and worse and worse. And
How was your mental health?
I was suffering from depression and I got some antidepressants and they weren't enough. And I went back and I got more antidepressants. Now I was having some anxiety also, but I never got anxiety medication because it can decrease your mental acuity. And I didn't want anything that was going to interfere with my mental acuity.
When was this?
This was the whole time. This is from 2015 on through the case.
When did it get increased?
It increased every time I saw the doctor. At some point, I was taking Zoloft and Wellbutrin, and I was taking so much Zoloft and Wellbutrin, it was over the FDA recommended dosage.
Did you ever tell Zach, my mental health is declining?
No, I never told him my mental health was declining.
Do you agree he was entitled to that information?
Probably.
Did you tell the court?
No.
Did you consider withdrawing at, say, when Jason Autry changed his proffer, or provided his proffer, January 2017?
I think the real turning point was when the judge didn't let Luke Evans be an attorney.
When was that?
That was in February, perhaps, of 2017, after Jason adjourned. Luke Evans had from the Board of Professional Responsibility an all clear. They said it is not a conflict for you to represent Zach Adams, that Shane Austin had died, that there was nothing further that the state could do against Shane Austin. And there was no way that anything that Luke did in Zach Adams' case was going to affect Shane Austin's criminal outcome. And so they said, you may represent Zach Adams.
Why did you ask to bring Luke Evans?
Because Luke Evans is a dynamite attorney. He was like me. He fights for everything. He fights for innocence. And he was going to fight this case and make it, he was going to help me win this case. And there was a turning point for the judge because the judge had been saying, I've talked with the AOC. We're going to get you a third attorney because we had two attorneys. Simmons wasn't doing any work on the guilt innocence part. He was only doing the mitigation work at that point. I was the only one doing the guilt innocence. That had not been my choice, but that's something he decided he would do that would give the jury more credibility. He would be more credible if he didn't take part in a guilt innocence trial. And so the state had four attorneys that were working on it. And so Creed McKinley had said, the AOC is going to let you have another attorney. This is an extraordinary case. It's out of the ordinary. It's like no other. It's the biggest investigation in TBI history. It has so much information, and we're going to let you have a third attorney. And Creed McKinley had said this to me. And then
Creed McKinley is the judge.
And we had a telephone call. I usually recorded my telephone calls with my recording pen. I had a very nice, I still do have it, pen that will record as you write things, it'll record what's being said. And so I almost always turned it on during telephone conferences with the judge, but I didn't on this occasion. And but my assistant, it was a call in, it was a large conference call. And I was in West Tennessee at Cracker Barrel with Luke Evans and an investigator or two, one or two investigators. And we'd eaten breakfast, and then the judge said he wanted to have a conference call. And we went out, and the judge said something to the effect of, well, I talked with Jennifer Nichols about this. And so right then I knew something was wrong. He had been talking to Jennifer Nichols about this, and what they had decided is that Luke Evans, if he came onto this team, this case was never going to settle. I fully believe that she said, if you bring Luke Evans on.
To what Ms. Thompson fully believes might have been said. This is total speculation.
This is speculation.
It is.
Objection sustained.
So the judge said, I talked with Jennifer Nichols, and I'm not going to let Luke Evans come on. There's a conflict. And so at that point, we had a big hearing about the conflict. The Board of Professional Responsibility, which is the board that decides whether or not there's a conflict, said there's no conflict. And the judge still refused to let Luke Evans come on the case.
Did you feel you needed another attorney?
I needed another attorney. I tried to find other attorneys that would come onto this case and try this case with me.
How many other attorneys did you try to find?
Multiple.
What did you do?
I called.
Okay. I know I was watching Defense Diaries last week when Jennifer Thompson was originally doing or testifying in this hearing. And I know that Bob Matos, and I agree with him, you have to get over these things in order to try a case. However, I do happen to know when you have to deal with certain people, I have a family member that will make me nuts and they know that they can make me nuts. And it's like death by 1,000 paper cuts. It messes with your mind. Up is down, down is up. You can be a very put together person. All of a sudden you're like, what is happening to me? I get it. And especially after I watched the first 2 days of the trial, you all will see it too. It's not an excuse for her. I understand. I'm not sure what the question, are they allowed to discuss those things outside of court? I'm not sure what you're referring to. All right, let's go to the next section I have for her. It was really important. I wanted you all to see or hear her testify about how difficult it was. And after we just saw that wretched woman on the stand, do y'all believe her? That she was hateful and aggressive? And because I do, I believe every single solitary thing this woman says.
You did not hit him with the Dylan Adams interview that he could have authenticated because he was there.
No, I didn't.
You agree he could have authenticated it?
Yes.
You could have gone through Jeff Jackson's behavior against Dylan to get a statement the state said they don't believe.
Yes.
Why not?
I don't know. I think I was overwhelmed at that point. I think that I didn't, we didn't know who was coming to testify. I should have also in advance, not just the night before, but in advance should have sat down and gone over these things and really thought out how I could get this material in. I don't know why I didn't do it. I can't explain it.
Do you think that was competent counsel?
No, I think I should have put it in. I think that the fact that the TBI was willing to go with one lie when it really didn't meet the facts, and then they were willing to go with Jason Autry's lie, which didn't meet the facts, would have been telling.
The jury never heard any of the Dylan stuff, did they?
No.
They had no idea there was a 4-hour interview that the state traveled on for how many years?
2014, 15, 16, so 3 years.
You didn't ask Agent Booth if he felt he coerced Victor Dinsmore, did you?
No, I did not.
Did you ask Agent Booth whether Victor Dinsmore told you what kind of gun it was?
No, I did not.
Y'all. So the fact that Dylan Adams gave this 4-hour statement, she never introduced it. Ma'am, that would have been really handy for the jury to see. You have one eyewitness testimony saying one thing and another eyewitness testimony saying something else. I don't know. I'm not an attorney. I just know what it would look like if I were a juror sitting on a jury, and it would look like reasonable doubt to me. Oh, yeah. Not effective counsel by any means. I'm going to take us to the next section of clips. I told you this was a long one, but we had a lot to go. Yeah, it was. It was an ugly one. Sorry, ma'am. All right, let me find this next section.
Death penalty, his investigation.
Bear with me. It's a coming. When I saw a bunch of this testimony, this hearing back in August, I was shocked. And I remember saying at the time, I don't normally believe that an individual has any chance for a new trial, but he's asking for a new trial due to prosecutorial misconduct. And we're going to be getting to that. You'll understand why in just a little bit. Prosecutorial misconduct and ineffective counsel. And I personally think the ineffective counsel, that's a done deal. Just by looking at what the testimony is, that we've watched. So here we go. I'm not entirely sure. I didn't write a note, so I'm not entirely. Oh, this was probably in reference to evidence. So
of 2014.
Take the court through your initial work after being retained in Zach's case?
Well, they kept saying that they were going to get me discovery, and they kept saying, we're going to get you discovery. We've got the discovery. We're going to get it. And so I was retained, I guess, in late February, early March
Of what year?
of 2014. And so then the district attorney, Beth Boswell, mostly, said that they were going to have DNA evidence because they had searched Zach's house and they had done all this testing on things. And she said, we're waiting for the DNA evidence.
There's
We're gonna have
none.
DNA evidence. And so that's when I got Jim Simmons to come on board as co-counsel. Jim Simmons there's a lot of death penalty cases, and he is excellent at getting a guilty plea out of a case that normally might go to trial, and he tried to end. And at that time, I believed Zach Adams was guilty. I assumed that because the state had charged him with a crime and they had been doing intense investigations, that he was guilty and there was going to be evidence of his guilt.
Can you imagine? When I heard this, I was like, what? What did she just said she believed her client was guilty right out of the gate? What? Ma'am. Now, as just a layperson, I will tell you, when this case was happening, I absolutely watched from my home and watched all of the news stations, and I absolutely believed these three did it. But ma'am, you're an officer of the court. Let me go to the next section here.
Why did they come into the picture?
Well, Fletcher Long had been tried for crimes and had lost his law license in Clarksville. And I think John Herbison had also lost his law license. And so we had two disbarred attorneys, or if they weren't disbarred, they were on probation and suspended. And so they couldn't represent Dylan. So we had Paul Bruno and Matt Maddox come on that spring. At the same time, they appointed Jason Autry attorneys that were Robert Paris and Mike Scholl.
Had you ever worked with either Mr. Scholl or Mr. Paris?
No, I did not know them.
Was it a still undefined defense agreement when they came on?
So I played that because the two attorneys that were supposed to be representing Dylan Adams were disbarred. What in the world is happening in Tennessee? Goodness. Like, seriously? Ay, ay, ay.
All right, let's go to the TBI physical evidence meetings.
Okay.
How did they go?
It went very badly. So at this point, there were 500 items to view, and I don't know how many of them were about 500 items to view, and I don't know how many of them were at the TBI headquarters. But I, at this time, believing Zach was not guilty, because the evidence didn't show that Zach was guilty. The evidence was showing me that Terry Britt was guilty. And so at that time, I wanted to go in and see all the evidence. I really felt, I was a very enthusiastic attorney, and I really believed that we needed to look at every piece of evidence in a case before you try it. And that was just a given. And the other attorneys did not want to look at every piece of evidence. And Jennifer Nichols, who I think is very astute at figuring out dynamics between teams, Jennifer Nichols insisted that we start with number one and go with item number one all the way through item 500. And we go in number order. And we were all supposed to look at this. Well, the other two teams were getting irritated and frustrated with me. They actually took me, like I'm the child, they took me into one of the other TBI lab rooms, because we were in a giant room bigger than this courtroom with all the physical evidence. So they took me into another room and said, Jennifer, what are you doing? Why are you looking at all this evidence? This is a waste of our time. And I said, no, I want to see every piece of evidence. And they were like, why do we have to sit here and do this? So they were trying to tell me, so this case involved a lot of people trying to tell me how I should do the case and how attorneys would do the case. And it was against what I believed a good defense attorney would do.
You complained about this to Judge McGinley at a
Well,
motion.
first I complained to Jennifer Nichols.
How'd
I
that
said,
go?
guys, pick out the items that you would like to look at, and then we'll look at those first, and then you all can go, and I'll stay here for the rest of the week and look at all the 500 items. And Jennifer Nichols said, no, we have to go in number order. And I'd never had a case where the DA stood over you and looked at the evidence while you looked at the evidence. And she was standing there right next to us. So if I said I wanted to see a pair of pants with a stain on them, then she knows that I think that that's important. So the other reason to not single out different items is because then the DA is going to get a hint as to what you think is important in the case and what you want to look at. So she said no. So we sit there and painfully go through, and the other teams are getting frustrated with me.
Can you approximate when in relation to Jason Autry's proffer?
This is well before Jason Autry's proffer.
Okay.
And well before, and this is before Dylan is going to testify and be a testifying witness for the state.
Okay, when was Dylan going to be a testifying witness for the state?
I don't remember when that happened, but when we were at TBI, we were all still supposed to be on a joint
I
defense.
see.
I say it in quotes because we really weren't working jointly.
Did you present your problems of discovery to Judge McGinley?
Yes, I went to court and presented the problems to Judge McGinley.
How'd that motion go?
Judge McGinley blew it off and said, well, they have a right to be there. They can be there while you look at the evidence. You know, usually there's a neutral person, somebody from a law enforcement agency that's making sure that you don't spit on the evidence and put your own DNA in it, mess up the evidence, but somebody that's neutral and that is not going to go back and report what you're doing to the other side. Judge McGinley poo-pooed my complaint.
Did the defense attorneys take up for you?
No,
Did they? All right.
Judge is doing a lot of writing.
Did your relationship with the other defense attorneys improve or get worse over time?
well, after this viewing of the evidence, and I've talked with the mitigation expert that we had hired on, a mitigation expert at this point.
Who was that?
Oh, now I can't remember her last name. Lee. You want to remind me?
If the witness could be past exhibit 34, but you could maybe just keep.
And a mitigating specialist psychologist that Jim always used in his death penalty cases. And Lee gave me some advice that I really held on to throughout this case. First of all, I was complaining to Lee that they didn't stand up, that everyone was attacking me, because when they pulled me aside at the TBI, all the defense attorneys were attacking me. Not so much Matt Maddox and Paul Bruno, but especially Mike Scholl and Robert Paris were treating me like a child and fussing at me for being so picky about everything. And I called Lee Norton, and this is the first time in all the years that I had practiced law that I really felt that there was sexism going on, that the men in the case were discounting what I had to say and the information I had because I was female. And they were all very masculine, not so much Matt Maddox and Paul Bruno, but Mike Scholl and Robert Paris were very masculine, man, we're going to do this cowboy type attorneys.
As you reflect on
Oh,
your
do
services
tell me more about that.
at this stage in your representation, do you feel you were competent?
At this point, I still felt I was competent.
You were diligent.
I was diligent. I was going to look through every piece of evidence. I was going to make notes and make sure that I knew what it was. And the things that I thought were important, I was trying not to look at extensively. And I was trying to throw them off a little bit by looking at some things that I thought were not important a little longer, just so that they didn't know what I was interested in.
So through 2015 through 2016, in a given week, how many hours would you work on the case?
I don't know, a lot,
40?
maybe.
Okay.
I'm not sure I billed 40 hours, but I didn't bill a lot of the time that I worked on it.
At this point, had you talked with Zach much?
I had never talked with Zach much. One of the problems with talking to Zach is Zach he did not commit this crime. And he didn't have any information. You know, usually your client's done something and you'll say, well, tell me what happened. Tell me confidentially what really happened. We're going to sit down and go over this. And then you take their side of the story and you look at the evidence, try to see what proves or disproves this. Zach didn't do this and he didn't know anything about this. And so he didn't have much to provide.
All right, let's stop here. And there's two types of criminal defense lawyers, those who say, don't tell me anything, or tell me what really happened. Is that a fair?
Sure.
Which one are you?
Don't tell me anything. So usually it's don't tell me anything, because when you get in there and you're talking to your client initially, the first few times, the client will say, oh, I didn't do this. I didn't do this. So now they've told you a lie that's between you and the client. So usually I say, let's not talk about what happened. Let's get the discovery. And then I get the discovery and I go back to the client and say, look, this is what the discovery shows. The discovery has DNA placing you in the apartment, or, you know, whatever it is. And then I say, how are we going to explain this? Then I want them to tell me everything. But I try to not have them tell me everything before I get the discovery. Does that make sense?
Did you have those discussions with Zach that you just talked about? Review the discovery and say, hey, did you do it?
I'm not sure I did with Zach, because there wasn't anything, you know, Zach early on said, I don't know anything about this. And so I probably didn't have many discussions with Zach about what was going on. And Zach was a little meth high. You know, he was short sentences, up and walking around. He was still I think his brain was still kind of methy.
Okay.
And he was not easy to really sit down and work with. I would have been happy if he'd have been, let's sit down and go over this, but he wasn't really in that disposition state of mind.
Any idea how many times you met with Zach over the course of the case up to the beginning of the trial?
10.
Okay.
at any time did he give you any cause for concern that he committed this crime?
No, never.
Okay, I'm going to take us to the next clip here. So would you want her to be your defense attorney? And I can tell y'all some of this that she is talking about being ganged up on and
But I do
everything.
because I love people.
It is absolutely, you're going to see it when we watch the trial, because I watched 2 days worth of the trial, and she talks about an instance. I think it's coming up here, and I'll pause when we get to that moment. Told you it was going to be a long one. Sorry, we got probably maybe another 30 minutes. So let me get us queued up here. There. Oh, for heaven's sakes, get it together here. It's Monday, but that shouldn't be an excuse. All right, here we go.
People. I fix things. I'm a hands-on kind of guy. Take charge and fix things. What's solving this case mean? Does it mean just picking somebody? No, because there's all this pressure being self-imposed. No, I would never do that. We never would do something like that. We pride ourselves on doing the right thing.
Is there a question for Ms. Thompson here?
Yes, yes. I can get to it. We pride ourselves on doing the right thing and always the right way. We make mistakes in this one, yeah. One I'll take with me the rest of my life. That's all, excuse me. But I got the right person. I didn't charge the wrong. Then you objected, line 23. Objection, Your Honor. I object. We're giving opinion testimony right now. I object to that. Then, General Hageman, I think it's enough. I'm not going to ask any further. Thank you, Agent Booth. And the court said cross. All right. Do you remember this part of the trial?
Yes.
Do you believe Agent Booth opened the door to whether he did things the right way?
Yes.
At the time, you had the recording of Agent Booth and Victor Dinsmore just several months before, correct?
Yes.
You did not hit him with that on cross-examination, did you?
No, I didn't.
You did not hit him with the Dylan Adams interview that he could have authenticated because he was there.
No, I didn't.
You agree he could have authenticated it?
Yes.
You could have gone through Jeff Jackson's behavior against Dylan to get a statement the state said they don't believe.
Yes.
Why not?
I don't know. I think I was overwhelmed at that point. I think that I didn't, we didn't know who was coming to testify. I should have also in advance, not just the night before, but in advance should have sat down and gone over these things and really thought out how I could get this material in. I don't know why I didn't do it. I can't explain it.
Do you think that was competent counsel?
No, I think I should have put it in. I think that the fact that the TBI was willing to go with one lie when it really didn't meet the facts, and then they were willing to go with Jason Autry's lie, which didn't meet the facts, would have been telling.
The jury never heard any of the Dylan stuff, did they?
No.
They had no idea there was a 4-hour interview that the state traveled on for how many years?
Sorry,
14,
this is a
15,
repeat.
16,
So my bad.
3 years.
You didn't ask Agent Booth if he felt he coerced Victor Dinsmore, did you?
No, I did not.
Did you ask Agent Booth whether Victor Dinsmore told you what kind of gun it was?
No, I did not.
Of the timeline of that morning as it relates to a window for a white truck to be hidden at Victor Dinsmore's.
Yes.
What is it?
Well, it's going to take them 30 minutes to get back to from the river to Shane Austin's house.
On what alleged route?
On really any route, unless it was the interstate. And Jason said they didn't take the interstate.
What was the importance of not taking the interstate?
Well, because they didn't want somebody to see the dead body in the back.
If they took the interstate, what would the significance be?
Well, they would have gotten back faster. They might have gotten back in less than 30 minutes.
They've had a body in the back.
Yes.
You think they would have driven the interstate
Objection,
with the
Your Honor,
body?
to the speculation.
Fair enough. Did you had your investigator run the routes from the alleged spot Zach and Jason were at the river?
Yes.
And do you remember the belief that there was enough time to get from the river along Autry's route back to where they were at Austin's house at the time frame they provided?
Before 11 o'clock?
Yes, ma'am.
Because Jason had to go eat
Yes.
lunch with his girlfriend at 11. I don't think there was enough time, no.
What route do you think they actually took?
Well, they didn't go. There's no real route. They didn't do it.
Do you understand
Exactly.
at some point, you understand where the cell records put Dylan, Zach, and Shane in Parsons that morning?
Yes.
What time?
11:20.
Okay.
I'm guessing. I can't quite remember.
Do you understand? What was your understanding of the state's timeline when a truck was hitting at Victor Dinsmore's?
I don't know what the state's timeline was. I'm guessing from Victor Dinsmore's trial testimony, the state saying they did it before they went to Parsons.
Did you explore when there was time to do that?
No, I didn't. I should have.
Did you discuss with the jury this timeline that the state was bound by?
No,
Why not?
I don't know.
Can you imagine? This is like some of the most critical evidence for his to raise reasonable doubt. And nobody on his defense team thought to check it. And this is absolutely what happens. Hello Kitty is saying, it seems like she was beat down and not enough mental capacity to deal with the judge, prosecutor, TBI, and the trial. Like she said, most prosecutors are friendly outside of the courtroom. Yes. And I'll tell you that Mr. Hagerman ended up being like a go-between between her and Jennifer Nichols because Jennifer Nichols was so awful. So I just can't imagine having someone's freedom in your hands. And I mean, I don't know what she could have done differently, to be perfectly honest. I guess just walk away from it. I don't know. I really don't. I don't have the legal acuity to know what her options were, but I can tell you it's messed up that a person can be put in this situation. And yeah, so, we're going to keep going.
I mean, first of all, it's terrible. She's leading him terribly. He's asked and answered and said he didn't remember. I mean, the objections I should have made to that, but
Did you
it's
have
hearsay.
Did you have Valerie Trout's statement, IR statement?
I probably did, but I don't remember.
Did you have Valerie Trout under subpoena?
No, I did not.
Are you aware of Rule 803-26?
That prior inconsistent statement?
Yes.
Yes, I reviewed it last night.
Okay. A statement otherwise admissible under 613B if all the following conditions are met. The declarant must testify at the trial or hearing and be subject to cross-examination concerning the statement.
No, she's testifying. She's familiar with it.
Was that met?
Yes.
Were the other conditions met?
Yes.
Why did you not then go to your computer and show the jury the Brent Booth Victor Dinsmore conversation at that point?
I don't know.
Was there any strategy involved in not showing that to the jury?
No.
Anything that you think that was hurtful to Zach you didn't want to present?
No.
Victor Dinsmore prior had said that at the fight in the afternoon of April 13, 2011, what did Victor Dinsmore say they were arguing about? Do you remember?
I get confused. Did he say that they were arguing about who was going to hit that or he'd let Shane hit that?
Was it your understanding Mr. Dinsmore was referring to a future event against Ms. Bobo?
Yes.
In this recorded statement, do you remember what Brent Booth said Ms. Holly's condition was at the time they were arrived that afternoon?
I think he said she was dead.
Does that make Victor's statement make sense?
No.
Why didn't you present it to the jury?
Gosh, I don't know, Mr. Bates. I think, at the time, I should have had this all prepared out in the beginning. I didn't realize how much everybody was going to lie. I thought that I would be able to use the cross-examination of their prior inconsistent statements against them. And I thought that they would just admit that they'd made these prior inconsistent statements, but everybody just lied about it and said they didn't remember. Usually in a case like this, the state goes over the witness's prior statement so the witness will testify consistently. But in this case, witness after witness was saying, no, I didn't review my prior statements. So the state hadn't gone over it with them to review their statements, and they came in not remembering, some of them not even remembering they had given statements.
Victor Dinsmore's cross-examination, page 1554. Disposed of that you got, line 16. Now, you also talked to Brent Booth about the gun that you disposed of that you got from Jason Autry, didn't you? That I had my wife dispose of. I got it from Shane. Your wife disposed of it because you suggested she dispose it, didn't you? Yes, I did. At first, you told Brent Booth also that it was a 357 or a 38, didn't you? Answer, yeah, I wasn't really sure what it was. Had you listened to the second recording of Brent Booth and Mr. Dinsmore when you cross-examined?
Yes.
What do you remember what Mr. Dinsmore said to Mr. Booth regarding the gun?
Not off the top of my head.
Your Honor, I'm going to play from the May 18th video recorded. Exhibit 64, the May 19th. Go to 17.
I'm going to
Your
scoot us
question
to the next.
on page 1554
Well, I'll wait.
was a 357 or a 38.
Yes.
Why did you phrase it that way?
I'm sure that's because that's what he had previously told law enforcement.
I'm going to play beginning at minute 7:02 of Exhibit 64.
So the reason this is so critical is my understanding is it was actually a 32 caliber shell casing that was found at the location where Holly's remains were found. So it's kind of a big deal. Oh, I am not in the right spot here. Bear with me. So we're going to continue to this next little spot. Before I forget, hello, Kitty. Thank you so much for your $50 donation. I do appreciate it. Always, always welcome. And I thank you so much because I know it's a choice, not something that you have to do. So thank you so much.
Did you emphasize with Mr. Dinsmore, he had already thrown a 32 revolver away?
No.
Did you emphasize when he made this statement in relation to when the gun was found?
No.
Do you know how many days before this statement was made?
No, but it was made before the gun was found.
You know how many days?
No. A few weeks, a few days.
Exhibit.
Revolver, chain, and chain, trading your revolver. I remember Shane. I remember now the Shane traded me a black 38 revolver. It was a regular revolver, but it was only switched to silver back 357. These things came to me and wanted to get the pills for it. I can't remember how many I gave. I think I gave some one time. The next time I got some, I paid him off, for the pistol. But then we started talking. We remember when Jamie Darnell moved in, was when mom and dad threw him out.
One gun, 38 revolver.
Yes.
Interchangeable 357.
Yes.
You made it seem like he mentioned possibly two guns. Was that a good question?
No.
Did you ever ask how is it that at one point Autry and Dinsmore both gave a 357 as the murder weapon? And then they both said at trial it was a 32 revolver. Did you ever connect that to the jury?
No, I didn't.
Why not?
I don't know.
That's a big deal.
You continually say you don't know.
Well, sitting here today, I do not know.
A competent, effective attorney had made these mistakes.
No.
You had poured your life into this case. What's going on? What was going on at this time?
I think at this time I wasn't prepared for trial. I thought we were going to get a continuance. I even thought when we showed up for trial on the day of trial in September that the other attorneys were going to ask for continuance. I had been chasing all these other leads that they had dumped on us in May and July, and I was looking up like all these other witnesses. So
I think we saw this part of the testimony. So I'm going to scoot ahead to the next little clip that I want to share. Yes, Lovely Flight. She was more than overwhelmed. And I really hope you all will tune in when we start the trial on Friday, December 5th, because you will understand the steamrolling that takes place.
You had been advised in these proceedings that there was shared in discovery a video from the ATM machine.
No.
in the post-conviction proceeding?
Oh, yes, I've now know that the state knew that there was a video of the ATM machine.
This is a really, really big deal, y'all. Really big deal. And you're going to see why.
And did I ask you to follow the file path that was provided in a motion by General Boyano to find us?
Yes. Yes.
And-
So on my Pegasus hard drive that I have, that was several $1,000s. I pulled it out, fired it up, and went through the process and followed the path that you said it would be to open up the video.
Were you able to open the file path from BP 413?
No, I could not get it open.
And did you take a screenshot of what your computer had? You can look at the document in past.
I guess I did.
And did you send it to me?
I guess I did. But recently, I mean, I did it just very recently too.
Let me ask this. Would it help you remember when you possibly sent this if you saw the email to my office?
Yes.
Officer, please.
This is just her authenticating the time and such.
What date was the email?
April 25th, maybe 2025.
And what's the date on the install this first to view on the far right?
Oh. April 3rd, maybe?
Okay. And is this what you?
Yes, this is the screenshot of it.
Your Honor, I move to enter this next numbered exhibit.
No. But I recently also got.
Okay. This next part I'm going to show you is probably one of the most critical pieces of evidence that I don't think ever saw the light of day. So I'm gonna fill in some details here before I get to this particular part of the story for Zach Adams. So I didn't play. He testified in this hearing as well. I did not play it because there was so much other information that I thought was important for us to get through. We can always go back at another time and we can watch that. But what he had been saying from the beginning is that he had gone with Dylan and Shane Austin. The three of them had gone to the bank and they went to an ATM machine. And not only did they go to the ATM machine, but he said, I knew that Shane had just gotten a lot of money and I didn't want him. He's a big jokester. I didn't want him to accuse me of doing any sort of funny business or anything. He said, so I drove into the ATM drive-through backwards. So the passenger side of the truck would be closest to the ATM for him to get the funds that they needed so they could go do a bunch of drugs. Kind of specific, kind of very important, and it was completely missed. So he had been, Zach had been saying that he had spent this time all along, and now I'm going to play the video for you.
Do you ever remember seeing, prior to these post-conviction proceedings, this photo?
No.
Which is a still shot of that exhibit. We marked it as a long exhibit left.
101.
If you had the timestamp of 11/12 of that photo,
11/12
in a jury trial regarding the timeline the state sought the jury to believe.
Yes, that's an alibi, partial alibi for the time that the state says he was committing the murders.
Did you have photos of that Silverado from being impounded by the state?
Yes.
That's a picture from the
You
ATM.
testified you were competent and diligent as an attorney in 2014,
Yes.
2015,
Yes.
2016,
Yes.
2017.
I think 2017 things began to change.
Were you
I think so
competent
too.
and effective at the trial in September of 2017?
I don't think so. I think that I was still trying very hard, but I think there was so much material, and I was the only one working with it. I was the only one doing the trial. And even if I had wanted to pull something up and play something for the jury, it would have been a monumentous task for me to find it in the discovery. One of the things that the state did is they would come up and they would present the witness with a piece of paper and say, here's this. And I would say, what is that she's handing him? And she said, well, she got it in the discovery, Your Honor. Well, I got 4 terabytes the first day. The first day they gave me discovery, I got 4 terabytes. And then they kept adding on and on and on to that. So I wasn't able to pull things in trial and show them. I was barely able to cross-examine witnesses. And it's not because I wasn't trying or I wasn't a good attorney. It was because the situation that I was plopped down into, and with the judge being so rough on me and the state being so ugly to me, it made it impossible for me to be my normal zealous self.
Ms. Thompson, do you agree that a competent attorney has to get past sometimes the state's mean to you?
Right, that sounds kind of babyish, but the state was so ugly when I would make objections and so ugly in front of the jury, I was worried that they were poisoning the jury against me.
So, one of the things that she talked about in her testimony was that she raised a hearsay objection, and the judge basically attacked her and then did like this big long diatribe to the jury explaining what hearsay actually was, and it was very sarcastic, and so it made her, again, like she just said, not want to make objections because she didn't want to create bigger problems and prejudice the jury against her client. Day 2 of the trial, because that y'all know that's as far as I got. Day 2 is when it happens. So she's absolutely correct. That is absolutely and exactly what happened. And I'm excited for us to explore this trial because it's just a little bit that I've seen is a roller coaster. So I hope that's given you a little bit of background as to kind of the craziness that happened. There were other suspects. There were things that were not followed up on. It's truly, truly tragic that a singular defense attorney was steamrolled by so many individuals that ended up costing someone's freedom. And I hope that Zach gets a new trial. We'll rewatch the trial itself. And I know there's another hearing December 29th and 30th. I think they're getting close to wrapping up this post-conviction relief hearing for the judge to be able to make a decision. I don't know if they don't do closing arguments on the 29th and 30th, then they will be doing them on January 6th and 7th because that is the next date. Let's see. Yeah, I don't have an answer. There is another hearing on the 29th. I don't know how long the judge will take to make a decision. I don't know a lot about this judge, and I certainly don't know a lot about the Tennessee court system to know how quickly there may be some resolution on it. I really feel like there appears to be some prosecutorial misconduct in the fact that there was some sort of alliance that was being played between the state prosecution and the judge. And I think it's even clearer when you watch the video of the trial. And obviously there was ineffective counsel. She's admitted it under oath. And we saw what kind of woman she was up against. So I am very thankful you all decided to hang out with me and learn all about this. Sorry we went really long, but I knew there was a lot that I needed to cover. So I figured it was going to be close to 3 hours tonight. Mr. Demeanor was fully aware. So Wednesday evening, this is right before Thanksgiving. I'm still going to do Wine and Crime Wednesday, and I know you all are asking about Courtney Clenny. So I will get my act together and put something together for us to do a summary and get some basics and some preliminary facts on Courtney Clenny's case. If you don't know what this case is about, Courtney Clenny is the OnlyFans star, or whatever you want to call it, that is accused of stabbing her husband, not her husband, her boyfriend in their luxury high-rise apartment in Miami. And he did not survive. Hey, Melissa. Nice to see you this evening. Well, I guess it is an evening for you. Well, no, it probably is by now. So we'll do a little summary and catch everybody up on the Courtney Clenny case on Wednesday. I'm still planning on doing the Sarah Grace Patrick summary, but it's going to depend on, I have some feelers out there for some possible guests come on and for us to talk about different things. So I'm not sure when that's going to materialize. As far as the replay of the trial, we will start on Friday night, December 5th. I'll go 3 hours that night. And then I'm planning on going 8.5 hours on Saturday, 8.5 hours on Sunday. And then we will do 3 hours every night. So Monday, Tuesday, Wednesday, Thursday. I'll probably take Friday night off, and then we'll finish it up on Saturday. It's like maybe a half a day if I have it timed out correctly. And they talk really, really slow. So we'll have it at 1.25 to kind of speed things along a little bit as well. So I think that kind of gives you a little rundown of everything coming up. I am super excited and so happy that someone close to the defense team reached out to me over the weekend. I hope that I'm doing justice for this particular case and for Zach Adams. I cannot imagine how frustrating it must be to be behind bars for something that you didn't do. And as more and more information comes in and I learn more, I'm more and more convinced that there's a really strong possibility he did not commit this crime. So with that, I want to thank you all for hanging out in this super duper overtime. And we will talk soon. Don't forget to do the likey, subscribey things and comment if you would like. Tell your friends so they can subscribe and view some of my other content. And I will be seeing you shortly. And you know, it doesn't cost a penny to be kind. So find someone to do something nice for today. If you haven't already, it's not too late. And as always,